And for the inquiry to resume, just a few normal announcements. First of all, if you could make sure, please, that you turn your mobile phones to silent. That would be helpful. Thank you very much. Second thing is, if we hear the fire alarm, it is the real thing. So if we do hear it, we go out to one of the two exits, either side of the room, down the stairs, and we congregate in the council's car park. Obviously, don't come into the building until we're told it's safe to do so. Everybody all right with stairs? Anybody got any problems? No? Okay, thank you very much. Now, hopefully, this is the last week of the inquiry. And all being well, I can't see any reason why it shouldn't be. I shouldn't say that, probably. So today and tomorrow we're going to be doing the legal agreements, and we've been asked if we could do the NHS, the health ones first. So that's fine. We'll start off with them in a minute. We've got a few things just to clear up first. I hope everybody's got my agenda. So has everyone got it that needs it? Yes? Yeah? Good. All right, thank you. We've also been asked if we could do the affordable dwellings and viability obligations at 2 o'clock, or round about 2 o'clock this afternoon, because we've got two people who can only join virtually. So we'll do as best we can, but I don't really want to sort of break off halfway through something. So we'll move something else up if we hopefully we'll finish health before then, I hope. And we might move something else up, but we'll have to see how we get on. Okay, so that's that. And then, so there's just a few bits and pieces to be tied up from our conditions session. So, first of all, the council have sent some very helpful. I've got Mr. Gambrel here. Mr. Digan? No.
Not today.
No, all right. Well, that's fine. I mean, you know what he sent, I'm hoping. And he's sent some helpful suggestions on various conditions that we have discussed. So I just want to make sure everybody, if there are any comments on those, first of all. The first one was the national landscape condition. I suggested some wording and breaking it up into two conditions. Mr. Gambrel made a small change. It was a trigger, wasn't it? And he suggested that it should be prior to reserve matters. I think I suggested it should be prior to the start of development. Can't really see why it shouldn't be attached to reserve matters. Anybody got any comments on that? No, everybody happy? Yep. Right, okay, thank you very much. Obviously, I'll have to have a think about it, but I just wanted to know whether you agreed. So that's okay. He also suggested the wording for a new employment delivery strategy, which hopefully you've seen. Hold on a minute. Were you happy with that, Mr. Gearing?
Yes, Mr. Bashforth confirmed we're happy for me.
That's all right. I actually had a comment or two about that, actually. So the wording was no development shall commence in the employment key phase, but I think it might. We don't actually know that employment is going to be one key phase, do we, particularly? So, I mean, I suggest that it's any key phase, including commercial and business uses, would be better. Okay. As shown on the parameter plan, basically. Because the obviously the phase, I mean, the general phase is shown on the parameter plan. We've had this discussion, haven't we? Key phases are different. And this is a big problem with the section 106, I have to say, but we'll come on to that. So, is that anybody got any comments on that at the moment?
Just checking. Do you envisage that then picks up the local centres as well, or are you focused
Well,
on
this is the
now?
council's suggestion for the actual employment area, I think, because they're talking about the as defined on the phasing plan south, which I think just relates to that area.
Okay, fine.
Yeah. Anybody got any comments on that particularly? Okay. Thank you. Foul drainage. Yeah, Mr. Gamble suggested a new site-wide condition, which is what we I think the 5 parishes were quite keen on. So he's suggested that, Miss Bonnie, you've seen these, haven't you? I'm hoping. I mean, it does need an implementation clause, I think, but I mean, apart from that, I think that's okay. Is that okay, Mr. Gearing?
Yes. Yep.
Yep. Foul drainage strategy. So that was then on he suggested revisions to H3 for the northern site, and this was to be at key phase stage. Again, any comments on that? I think that the whole point was that there was rather a lot of these conditions, so we were trying to regularise them a little bit. And in the south, he picked up the point. I know you said, Mr. Gearing, that on your intel, the Kent Science Park was actually now connected to mains drainage, but I mean, we haven't got actually any evidence of that, have we? So he suggested some wording there to pick that up. Yep. I'm presuming are we all right with that?
Yeah, we agree. There isn't any evidence to show it.
No, so we've still got, the feasibility of connection, and obviously if it is connected, then
that's resolved.
That's resolved. Right. Okay. So everyone, no comments on that then. Thank you very much. Ecological mitigation. There was a suggested. This was one of the ones that there were, about 3 stages that people had to comply with, site-wide, and then I think phase, and then development parcel, and each involving new surveys, which I think we thought was a bit onerous. So we've got a site-wide one, and then he suggested one at key phase stage, and then he's at the development parcel stage suggested a construction ecological management plan. So is that, anybody got anything on that? Was everybody reasonably content?
That followed the discussions that Mr. Bashford
It did, didn't it?
Yes.
Yeah. Okay, Miss Bonnie.
Sorry, could you just repeat the last sentence?
I said that the suggestion is that there'll be a site-wide ecological mitigation and enhancement strategy. Then there'd be a key phase one, and then the individual phases. It will be a construction ecological management plan. So that's when construction would start, and the requirements would be for that.
Yeah, I suppose the only issue is if it stalls and it sits there for years for any reason, any particular phase.
Well,
if there's a retest at some point.
Oh, you mean for the surveys?
Yeah.
Well, I think the individual. Hold on a minute.
So on the B10.1, it says a strategy for updated surveys to be carried out, having regard to the guidance. So
yes,
it would be picked up there.
Yes, I think so. And then H10, I'm just looking, is it development parcel or is it phases actually, come to think of it?
Another parcel.
Because it's got, yeah. Oh yes, development parcel, that's right. So yes, it would be picked up, Miss Bonnie, I think, under the condition. And then also we were talked, didn't we, about the noise, having a possible noise condition for the strategic, the two strategic roads, the northern one and the southern one, and he suggested some wording for that, hasn't he? So I don't know if has anybody got anything? Are the applicants happy with that?
Yeah, just to confirm, that was through negotiation with our environmental health and acoustic consultants as well, going back and forth.
Oh, I
So
see, right,
an agreement
okay.
between us.
Good, so everyone's in agreement with that. Are they? Are you all right with that, Miss Bonnie? I would have thought you'd welcome that, probably.
Yes.
Thank you very much. Just one point I did just think of, actually. Well, I've been thinking about it actually for quite a while, and probably should have raised it. But there's nothing in here about public art, is there? Or any sort of. Now, I just wonder whether anyone has got any thoughts about that. There's obviously, as far as I could see, no. Unfortunately, the development plan doesn't, or at least the local plan doesn't have any policy. But on the other hand, it can be quite important, can't it, in placemaking? And maybe, I don't want you just to have to think about it on the hoof, but yes.
Agree.
There could be a condition, actually. It doesn't have to be.
The only challenge is thinking about the policy basis for it, but we could,
Well, it doesn't have to have a policy basis.
It could be integrated with the landscape and open space strategy requirements,
Possibly.
rather than it being a standalone
Yeah,
requirement.
possibly, yeah.
So that if you've
It doesn't
delivering
have
trim
to be
trails
actual
and other
art.
routes.
It can be all sorts of things.
It can be all
be a
sorts
sort
of
of, it can be some sort of natural thing.
Yeah.
You know, a carved. I don't know if any of you have been to Wisley Gardens, but they have lots of carved trees and all sorts of things like that.
It could be, I think it could be integral to the prow improvements on site and things. Having some,
Yeah.
there's quite a few.
Would you like to have a think about
Yeah.
it? Thank you. Right, so anything else on the conditions that I've missed? What is everybody? Hopefully I've picked up everything. Okay, thank you very much. Put that away. Right, okay. So the only other thing that we have had in, there are two other things. Radfield Farm we discussed, didn't we? And there's been a bit of toing and froing, hasn't there, on that? We've had quite a lot of information which has been put on as inquiry documents. So is that now complete? It would be obviously for me to consider, won't it? Secretary of State.
Yes, yeah, we've provided.
Nothing else to be said. Yes.
Nothing else to be said.
All right, thank you. And the final thing is, Stones. Going back to Stones Farm again. I think you, Mr. Gearing, are having a meeting this afternoon with the with Natural England, aren't you?
Yes.
Remember that?
Yes.
So it's probably best to talk about any outcome of that tomorrow, is it really?
I'll make sure that it's not in my diary, but it should be.
Well, it's in the afternoon anyway, I think. Yes. Okay, we'll come back to that then. Just what I reminded you, wasn't it?
Really was.
Yes, Miss Bonnie.
That's all right. Thank you, Mum. We've obviously written a note on that, but obviously we didn't want to write dozens of them. Should we wait the outcome of the discussion?
Well, you've done a note, haven't you? We've got lots of. We have got.
No, the council's written one and the applicant's written one.
Oh, right, okay.
I said we'd hang off pending.
Okay.
Obviously, the applicant has now responded and then is now having a conversation with Natural England.
Okay, well.
Don't want to bombard you.
No, quite. Yes, no, that's fine. I mean, we obviously need to clear it up and everybody needs to have said what they've got to say before the end of the inquiry.
Yeah.
But if we're going to be updated tomorrow morning,
then I'll hang off.
Then perhaps you could just hang off till then.
Thank you.
Right, okay, thank you. Okay. So is there anything else anyone wants to raise before we start? No? Good. All right, thank you. Right, let's turn to the section 106 then. There is that issue. I hope that everybody has been circulated with my comments about phasing and the definition thereof. I'm not sure whether we need to worry too much about that with the NHS here. Whether we could discuss that afterwards. Ms McKeegan, do you think?
I think that would be appropriate. I don't think it has a bearing on the NHS schedules.
Not particularly, no, I don't think so. So shall we hang fire on that and get straight into the health schedules, which, hold on a minute, rather embarrassingly, I've now lost. Hold on a minute, sorry. Oh, it might be. Sorry. I know I took them into my room. They might be. Oh, she's not here anymore. I've got so many bits of loose paper. I'm really sorry. I think I've left them in my room.
We do have spares, Mum. If you.
I know, but I've written all over them.
Oh, I see.
So, all my notes. Would you just bear with me just 2 seconds, then, please? Oh, no, they're not here. Here, are they? No, just 2 minutes. There. Oh, yeah. Have you got the health schedules? They came later, and they're on schedule 9. So could I just see if I understand this correctly? And this is the arrangements for primary care. If I could just tell you what my understanding is, because it might not be right. But as far as I understand it, in terms of the northern site, we've got either a contribution to increase the size of the Memorial Hospital, or we're going to the healthcare centre would be built on the northern site, either by I'll just say the NHS, just as a general, either by the NHS or by the applicants. So I think that's the northern site on its own. Is that correct?
Yes, if there's a financial contribution, it would be up to us to decide which primary care facilities locally it would go to. That's more accurate rather than saying it would go to the Memorial Hospital.
And who is it? Is it the Primary Care Trust that decides?
NHS Kent and Medway one. It's the integrated care board.
Oh, the Integrated Care Board. So where
Can you make
else-
sure you use mics? Sorry.
Yeah, don't forget your mics. Sorry. So if it wasn't the Memorial Hospital, is there another option where it could go then?
Well, there's a small number of existing primary care facilities that it might go to. It would depend at the time where the best use of those resources would be.
Okay. All right.
So it can't really be more specific at this point in time.
All right, so just making sure I've got the understanding correct. So if it was for the larger site, if the Secretary of State decided to grant permission for both north and south, then I don't think that there is a contribution option. Is that correct?
Correct.
Right. So the options are either a larger unit would be built on a larger site on the northern site, and that was why the commercial 220, or I can't remember how much exactly it was, square metres site was taken out.
That's correct.
Yes. Or a large site could be built in Oakwood North. Right?
Yes, on the southern side.
Right. And there are again two options, either the NHS or the applicants would build it. But if the NHS built it, as I understand it, you couldn't really impose an occupation trigger.
No.
So that's yeah. So is that right? I've
Yes.
Got it all right. Good. Okay. So has anybody got anything to say about that overall? Yes. Bonnie.
Surprisingly, the community are not very happy about that. I think, obviously, I sent you some numbers which shows the stress that particularly GP facilities in Sittingbourne are under and the issues that we face. I think having no certainty as to where that would be delivered, that facility, is a great cause for concern for the local community. I've got a question actually for the NHS on that, because when it's delivered, presumably anyone can join that facility to use the GPs, any resident within that catchment area. Okay.
Is that
So,
correct? Sorry, I didn't. I was...
So if they,
Yes, that's correct.
if for example, you opened it in, say, the Memorial, that capacity that's created could immediately be swallowed by the existing population. So the new incoming residents would not necessarily benefit from that.
There's a potential that they may have to travel further for their healthcare needs, yes.
So I think we need to have clarity that the incoming residents would have the benefit of the new facilities and not put additional strain on where those services are currently provided. I think we've already had discussion about Memorial.
Yes.
And in that breakdown of numbers I gave you is actually the short list of the number of GP facilities that already exist in the Sittingbourne area that cover Sittingbourne and the surrounding villages. This kind of flaky approach of we're not sure whether we're going to put it in the north or the south. We've been through an awful lot of transport evidence. We've been through an awful lot of planning evidence to tell us that this will be a sustainable development that will not be putting considerable strain on other facilities. But if we're finding an outflow of traffic to visit healthcare facilities, I think that just rides a horse and cart through some of that evidence.
I suppose the thing is that you, if a healthcare facility is placed, if it's on site, then it has to be sufficient size to accommodate the new residents. But as I understand it, there is also it's also going to be larger than that because the ICB wants to have additional capacity to cope with some of the existing shortfall. Is that right?
No,
Because I thought there was a funding gap.
that's only in a north-only scenario, madam. So,
Yes, the north only.
yeah, in a north-only scenario, we would have to build our minimum viable facility, which is 840 square metres. And that is... that translates to something larger than the north residents generate.
I see.
So we would have to try to find a Section 106 or maybe even a SIL payment from, you know, a neighbouring facility, like a local authority like Maidstone or something that could help us bridge that.
So the money isn't available at the moment.
No.
Sorry, why would Maidstone contribute? That's a completely separate district.
Yeah,
It's the same.
it's because Maidstone have a SIL regime, and Maidstone have a new settlement called Lidsing in their 2024 adopted plan, which is a garden settlement of 2,000 plus houses, and it's located to the north of the M2, just really directly to the south of the Medway towns in the Capstan Valley.
I see. But I mean, the point about that Miss Bonney was making is a valid one, isn't it? That, you know, you don't want to have a site of 1,250 or 8,400, I think it is, dwellings, not having access to primary health care. And that's what, I mean, I said this actually last time you were here, that I think, to my mind, if it is to be a sustainable community, it needs to be on the site of this, you know, the community that you're trying to make sustainable. And I personally, and I know that there's no power to enforce this, but I would, you know, if the Secretary of State were minded to allow it, I would, press very hard, really, for facilities actually on the site and not somewhere scattered around the, you know, the existing community. And I mean, the Memorial Hospital, I don't know if you've ever been there. I was asked to go there, and I mean, you know, I don't even know how you could enlarge it, but because it's got parking all the way around it. But I mean, it's, you know, there was, to be fair, some empty parking when I went, but, you know, it's not that easy to get to. And that's what the evidence we've had, that people find it really hard to get to. I don't know where the other ones you're thinking of, but, you know, they're going to be away from all these people that would be on the site. Personally, I mean, you know, whether it's an Oakwood North or the northern site, if both were to be allowed, permitted, you know, I think, you know, they've probably both got advantages, but and I wouldn't get too excited about that. I mean, you might have a view, Miss Bonnie, but you know, on the site, I would have thought would be pretty essential, really. But that's just my view, and I'm probably overstepping the mark, but I quite often do.
Mum, could I interject slightly? It's just to confirm, it's our preference for on-site. And secondly, we've had discussions with Mr. Dyker, and there are other Section 106 contributions from other planning permissions that have been granted that have been collected for the NHS but not been allocated to a facility. So there is funding. I've asked a number of times to see a list of all the contributions that have been collected and not spent, but no one's been able to provide that. But our understanding is there are Section 106 agreements that could help meet that funding gap on the north. You know, we've discussed a number of planning permissions that have been granted in the vicinity, all of which have collected funding for the NHS.
Okay. Do you want to say anything? Yeah.
In the event that both sites are approved, there wouldn't be any intention of providing it off-site.
Well, no, because there wouldn't be a contribution, so they'd have to be on site.
Yeah, and you know, that for that number of people, you would absolutely expect for it to be on site. It's only if just the northern is approved on its own that 1,250 units wouldn't necessitate a facility of its own.
The trouble is, 10 of them have already lost their GPs, haven't they?
And that's why it was. That's why the slight vagueness, if you like, on where it would be, because by the time this comes around, maybe Tenham will have re-provided a site, so there could be another option for investment of that contribution.
What do you mean on the Frognall Lane development?
Yeah, they have another option which, you know, they're looking at the moment, but there's absolutely no guarantee. So to actually name a premises is more difficult for us because, and I think it's safe to say that Sittingbourne Memorial Hospital is not our preferred option either.
Okay. Yeah, Mr. Townsend.
Just responding to the comment about alternative locations, we've been told by a number of times that the site allocated for the NHS on the Frognall Place development is too small, even for the 600 home, even for the 297 homes that is proposed for that development, and that is currently why I understand that the developer can't roll out the NHS allocated space on the Frognall Place because it's not even big enough for that own development.
I see.
So the chances of expanding it to a greater people is 0.
Well, I mean, if it's how many houses is there on there?
On Frognall Place, from memory, I think it's 297. I think it's 297, 298 houses.
Well, if 1,250 houses isn't big enough to support a surgery on its own, that certainly wouldn't be, would it?
Sorry, may I clarify? It was the physical space that's been allocated.
Right, well,
on the,
yeah.
So the physical, it's minute.
I see. Okay, well, there we are. Any comment? No.
Sorry, can't answer that, but we can have a look at that.
Yeah, okay.
Just to confirm as well, with the north only option, we are providing enough land for an 840 square metre facility, which is the NHS minimum. So, and that is safeguarded. So even if the land is provided and the funding from the north, and then other funding comes in from other schemes, we are providing a suitable size scale of land for the minimum size NHS, which has been the problem elsewhere, I think.
I mean, if, you know, Frognall Place is just next door, isn't it? So, you know, if there's not a site there, then that's even more reason I would have thought to put it. But there we are. Yeah. Miss Bonnie.
Yeah, thank you. So we agree that if the north only goes ahead, then there should be the surgery on the north. It's clear from those numbers and from what the NHS have said is that they need to upscale capacity. So that's an agreed point between everyone, I think. that they need to upscale their capacity. So the delay in the trigger of providing that facility, because they will have to put their own equity into the scheme, I don't understand why we, the existing community, should be burdened with accepting more patients into our surgeries whilst that facility is built. If they accept they need to invest and they need to put some money into that surgery.
I think it's going to be paid for, isn't it, by the development? I mean, if the NHS do build it, then there is a contribution, isn't there, for the building of it, I think.
There's a contribution of 1.66 million, which is the amount the NHS have requested.
So it won't be the NHS that's going to be paying for any of it. But I mean, the thing is that you can't really, the way these things work, you can't expect the developer to fund existing deficiencies. But if it is a bigger site, obviously, with this funding gap, then obviously that's a different matter, because the funding for the gap bit will come from somewhere else.
Yeah, that's the equity bit that I was talking about.
Yeah, but that won't be from the NHS. I would have thought that would be from another development, i.e. Frognall Place maybe, or I don't know. Or one. Well, you said, didn't you, that there was other sites?
Yeah, and it could be the NHS as well. We don't know, but there are other funding mechanisms, and there are other Section 106 agreements with funding.
So in essence, just to recap for my residents' understanding and me, is that so the developer will put forward X amount of money towards this, and the NHS ICB are saying they will only rely on developer contributions still to put in the additional to make up for it. They haven't got an investment plan to back that out. You have no bridge to pay for that equity. So you have no plan to enhance the existing facilities across Sittingbourne, but in particular there.
I don't know, do you want to? Is there anything? I don't know.
There isn't funding available for increasing capacity due to new developments, apart from developer contributions.
And from the community perspective, we would like that clearly set out to the Secretary of State, that position for us that we face in Sittingbourne with our dire GP ratio.
Okay. Noted. Okay. So, thank you. So just going through the schedule, I'm just looking at the northern site at the moment. The southern site, a lot of it's the same, and we can just pick up any differences as we go along. So the healthcare contribution, then, as Mr. Going said, this is this would be the amount that we will be paid if the NHS were to build the facility, isn't it? 166,872.
Yes.
But it could also go across to the southern scheme if the southern super facility were to come forward, and if the applicant were to deliver the healthcare facility in that scenario, then that funding would be drawn down by the applicants to deliver it.
Yes, is it the same amount? Probably.
Yes.
Probably a cross-reference. Yes, it is. Yes. Okay. Yeah. Now the acute care contribution, I think. Maybe I don't know whether I can. It seems it doesn't mention anything about a blue pencil clause on this one, just for the northern site. The 1.5 million contribution, Mr. Gearing, does that, or Ms. McKeegan, does that mean that you've accepted for the northern site that an acute
No.
care contribution should be made?
No, the position on the acute care contribution is the same for both agreements, and both of those contributions are subject to the blue pencil. I'm just referring to the front end of the Northern Agreement, where I believe we make reference to that being a blue pencil.
Do you? Somewhere? In the actual deed itself, you mean?
Yes, that's right.
Right you go. And the contributions, when we had our last round table session on this, I think the way that the contributions were, you know, how they were arrived at, I think has already been discussed, hasn't it? We've got information on that, so we don't need to go over that again. I just wondered, actually, just interestingly, because obviously for the northern site, it's proportionately much lower than the southern site, isn't it? Well, it seems to be. Or is it a proportionate?
It is proportionately smaller than the southern site, ma'am, yes. But that's because the council have asked us to reduce our acute contribution on the northern site as a result of the affordable housing.
Oh, right, okay. So that 1.5 million actually takes account, does it, of other contributions, doesn't it?
Yes, that's the sum. Mr. Dwigan probably best to explain how that's come about.
So, ma'am, the acute care contribution in full for the northern site is around about 4.5 million. However, that has an impact on viability and the ability of the scheme to deliver affordable housing.
Yes, of course.
So the council is increasing the proportion of affordable housing to 10%. Otherwise, it would be around about 4%. Now, in order to achieve a 10% level of affordable housing, the acute care contribution needs to be reduced from 4.5 to 1.5 million. And then when we come to it, ma'am, the viability review, if there's a surplus identified, if market conditions change, then part of the surplus could be used to top up acute care for the northern site or additional affordable housing.
That's not currently the case in the drafting, that suggestion that the surplus could be used in that way.
At the moment, the agreement doesn't say that, but that was certainly the intention.
Well, we're going to talk about surpluses and viability, aren't we? And when we come to the affordable housing, I'm just wondering whether we could talk about it then, because I've got a few questions about that. Anyway, shall we?
We can
hang fire
park
on
it. We
that?
do just note, as we're parking it to come back to after lunch, we do note, you've had lots of evidence on this, obviously, it is of interest that the council's position in respect of the northern scheme is to try and ensure 10% affordable housing in the first instance. And given the debates about policy and all of that in the evidence, that is a notable position for the council to take. We'll come back to it later.
Well, maybe that's what. Okay. What you're saying, that they're recognising that 10% is the justifiable amount.
I appreciate we're not talking about the southern scheme, obviously. We're just talking about the northern scheme at the moment. But well, it's really a question for them what they think the policy basis is. But obviously,
Is that what your
that is well,
inference
it's that is an inference, yeah, that we have been struggling with, because if their position is that it would be inappropriate, that 10% would be inappropriate, and it should be. Well, you know what the evidence was. I'm trying not to go back over all the evidence on it, but let's just put it this way: the council's drive to achieve 10% as a minimum on the north would be consistent with our primary evidence on how the policy works.
Maybe they just thought it was better than 4%.
That's
Maybe.
correct, Mum.
Well, I mean, 5% is better than 4%. Why 10%? Why adjust the NHS acute contribution to a level that accords with what's in the policy? But anyway, I'll leave it.
I presume that you're going to say it's not your...
Yeah, no, the aim was 40%, but as we were down around about 4%, Mum, we tried to strike a balance between acute healthcare and affordable housing. So it could be increased further, but then the NHS would be left with nothing. So we tried to strike a balance between increasing affordable housing, but not leaving the NHS with nothing.
So it's then an arithmetical coincidence that the precise percentage that the council's alighted on is accords with our specific reading of the policy, it would seem.
Okay, well...
Madam, could I just make a drafting
I'll come to you, Mr. Townsend.
Sorry.
Ms. Thomas.
Only that I think that where there is a reference to healthcare contribution acute in the schedules, that they should start from the position, just explain the position that the contribution did start out at 4.5 million, obviously, which is the SIDM derived figure, etc. And that just makes it clearer, hopefully would make it clearer that it has been reduced down for viability reasons. But as there is this, I believe, this clawback viability review, or maybe two of them, then it makes sense to just make it clearer in the agreements that that was what was sought.
Just to ask you then, so you're content with the 1.5, are you?
Well, we're not consent, but we accept that viability evidence has been produced, and in consultation with the local authority, we understand the reasons why they have reduced it. We don't wish to produce our own viability evidence of the whole of the Highsted Park developments, and rely on the councils to have done that.
But I mean, you could say... Sorry, go on.
Sorry, so that's the reason why we accept it. If it's if that full contribution is not viable for the developer.
But I mean, you could say, couldn't you, that you think that the acute care is more important than the affordable housing? That's what you could say, but you haven't.
We could say that. I think.
But you're not saying it.
Our view would be our view that I think my instructions are the view that probably take the view that it is.
What you think it is more important?
I mean, we would take that view that it's more important, but we understand the council has a process whereby if there are viability issues, then they go down a list and strike a balance. So it wasn't felt to be our decision.
Let's see. Okay, Mr. Townsend.
It was just an observation that, so for the northern site, you've got the number of people, the number of dwellings is 1,250. Mm-hmm. It is 1,250, so there must be some sort of ratio for the amount of care that those people need, i.e. basically you can't suddenly reduce down the acute care costs because the same people are still going to be needing looking after long term. And what you're doing here is you are then short funding an already constrained facilities for the NHS, that the people moving in will get a much worse service than they're already getting now.
I suppose it's all about choices, isn't it? As we're
Absolutely,
always
but-
being told.
Absolutely. But the point I'm making there is you've got 1,250 dwellings. They will have a number of people, whatever that number is, and they will need looking after. The number is fixed, but the allocation of money to look after those people, give or take, is being reduced by 60% down from 4.5 to 1.5. That means the amount of money allocated per person.
Yes, oh indeed. It's
Fundamental
a choice,
thing.
Isn't it? I mean, basically, if it's not viable, there is a certain level, we're not going over all the viability evidence again, you know, if there's a certain amount of money, then you've got to choose where it goes. I mean, maybe you might say you think it's more important that you have the health care than the affordable housing. Others might take, and council obviously take a different view. So, you know,
I acknowledge, but I think it's just all I'm doing is stating the fact
yeah,
that there is a limited amount of money in the pot,
yes,
and how it's split. But for me, and for the feedback that we are having from multiple sources about developments, this particular one, is that we need to look after people. And
what
you
about
can't-
people that need the affordable housing?
Absolutely.
You can't do
But then one
everything.
might there's a bigger question and debate about affordability, full stop.
Well,
But I don't go down.
okay, all right, thank you. Did you want to say anything, Mr. Digan?
No, it's just to highlight that, you know, it's a very difficult choice we've got an affordable housing emergency at the same time, you know, people need acute care. It's not something that we've taken lightly. So I've taken it through various committees within the council to get a steer from senior staff, and this is the outcome of that. So it's certainly not something that we've done lightly. We understand that the reduction in the acute care contribution will have an impact in terms of being able to provide acute care. Equally, we've got an affordable housing emergency, and to some degree, having decent housing can help to keep people well. So, you know, it's very difficult, you know, asking senior staff, what would you rather have, more affordable housing or healthcare? It's a very difficult situation.
Is it but it's not just senior staff, is it actually the council's position?
Well, the executive.
Well, I don't know, the councillors or the, you know, have
Well,
you
certainly
taken it
the-
to your full council, I think.
Not to the full council, no, ma'am.
So is it, so who, I mean, who's decided, I suppose you could say?
So the directorate management team and the senior management team.
Okay. But it is, you are saying that reflects the council's formal position?
Yeah, that's correct.
Okay. Okay, well, you know, I don't see any point in carrying on the debate, really. It's, I understand what the point is, and obviously the Secretary of State will have to decide. I mean, I don't think actually there's any clause in here at the moment that allows the Secretary of State to increase the amount, is there? Or is there? You see, there's no clause, I don't think, that says that the Secretary of State can play around with numbers as things stand.
No, not from that. No, not up from 1.5. No.
Do you think there should be? Or not?
It wasn't requested, it was drafted on that basis.
I'm asking it now.
I suppose we're disputing the
You don't think it should be?
we're disputing the cost as a whole.
Yes, I mean, we
This
don't want...
We lose.
We're not talking about the numbers, really. Well, I mean, we're...
About the principle.
Yeah.
It would seem sensible, man, to give the Secretary of State that option. I can't see any downside
For what?
to it.
This just goes back to the question of principle.
Well, I mean, first of all, the Secretary of State's obviously got to be satisfied on the amount, which you're disputing anyway. I
We
appreciate that.
dispute the principle of the sum.
Yeah, but I'm just talking about
But getting
the figures
beyond
in
that.
here. And the figures in here, I mean, everybody can see that 1.5 million is not proportionate to the 9.6 of the southern site. So, and now we're being told that actually it's a deliberate sort of choice, if you like. But what happens if the Secretary of State thinks that acute care is more important?
Then I guess the flex would be to reduce the affordable housing on the northern site and increase the...
Exactly, but
yeah.
there's no power to do that at the moment.
No, it could. We know what those figures are in terms of
You know what the figures are.
the percentage of affordable housing what it would need to drop to, but then that would need to, obviously that part of the schedule would need to change.
Mm-hmm. I don't know. I mean, I'm just posing the question, that's all. That's what we're here to do, isn't it? Really?
Yeah.
At the moment, the base provision, the definition of affordable housing base provision, enables the Secretary of State to decide between 11.28%, where the acute care contribution is not deemed payable, or 10% where it is, which is based on the 1.5 million.
Mm-hmm.
I suppose it comes down to what it comes back down to the evidence we've gone over is what's the evidence behind the overall sum as well, and whether a negotiated position, which we understood the NHS were happy with before this session. So we understood the 1.5 million was agreed between Swale and the NHS.
I don't know, maybe it is.
Well, that...
I'm only asking a question.
No, it's an interesting question. Ms Thomas said that the NHS's position was that they were content, was the word she used, with the 1.5. And if that represents their formal position, then that is it. I mean, they might want more in an ideal world, but if they're content with the way that things have emerged from a negotiation with the council, that should be as far as the Secretary of State needs to go.
Yeah, but there are the sort of other voices which are saying, well, you know, it means that people, you know, people's care, people who are living here won't get the care that they need, health care that they need.
Yeah, but it's very difficult to try and disentangle. I mean, our real answer to that is obviously goes back to the principle of the payment in the first place.
Well, it is the principle. I mean, this is on the basis.
On the basis.
The Secretary of State feels that,
Of course.
you know, there should be a payment, obviously.
I mean...
Ma'am, can I just add that from an NHS perspective, we were told that 1.5 million would be the amount that the NHS could be afforded for the Northern scheme. There wasn't an awful lot of negotiation. And recognising that is significantly less than the initial request, the outcome of that would be that we wouldn't be able to build the full capacity of the inpatient beds that this population generates. So you're right, the existing population would continue to suffer as a result of not being able to afford that full capacity.
Well, until presumably other sites come up with their sections at 106s.
Correct. Well, correct. But I mean, that figure's been calculated because the population generates this capital figure because of the population health needs that this new population will deliver.
I mean, as I understand it, the 4.5 million, if that's the full amount, that will go towards this new unit. And a new unit, I think we had evidence before that new unit could be built with that amount, although it's obviously not maybe not as big as if it had the full, you know, a larger amount. So we've had all that evidence, haven't we?
Yeah, madam, when I said actually that I was content that there was a viability evidence produced by the local authority, which is what I said, and that's because we haven't produced our own, and from that point of view, to a certain extent, you know, we are in the hands of the local authority, and that's why we presented with the 1.4 figure because we understood that's what
1.5
worked out from their viability assessments.
1.5. Yeah, 1.5.
1.5.
Yeah.
Sorry, yeah.
There would need to be change to the drafting, but we could put that figure in there. I think it's 4%. I'd need to double check. But if the Secretary of State felt acute care contributions were more important than the affordable, then the full contribution, 4 million odd, and then have a reduced affordable housing figure for the northern site. But I think it's round about 4 to 6%. I can't remember exactly, but it's a very low number. And it's bearing in mind we have an affordable housing emergency.
Well, yeah, of course. And, I'm not saying what the Secretary of State would do, but given that it's been raised as an issue, the Secretary of State really has got to turn his mind, I would have thought, to that. You can't just say, well, just take it as it is, something.
Mum?
Yes.
So I must say something for the 5 parishes group here, is that we're pretty aghast at the position we find ourselves in, that this was an infrastructure-led development that would be providing all the necessary infrastructure. And what we are debating here is that hard choice between affordable housing and health. And what we've demonstrated as a group is that our health service is totally overwhelmed and under-provided for, and there is clearly no plan to improve that. And in accepting lesser payment to the NHS, we are then depriving the existing community, as well as the incoming community, who need adequate provision. And we would like the Secretary of State to make that decision as to which group they're going to deprive. Are they going to deprive affordable housing, or are they going to deprive the NHS of funding? Because that, to my mind, is the clear choice, and my groups, and they are very passionate about this particular issue because of the day-to-day issues they face in obtaining NHS healthcare provision.
So you're saying that you think that the full amount should go to...
Yeah, absolutely. We can't be in a deficit, even more of a deficit position, I think, is what this is. We might have a very substantial road infrastructure, but what we're saying here is we're going to give de minimis amount of affordable housing, even less than the thresholds, and we're depriving the NHS, so both lose.
Yeah, I know, but the thing is, what we're talking about now is if planning permission's granted, you're talking about, well, it should just be turned away. What we're talking about, because if it's turned away, it won't need a Section 106.
So our community's view is that health overriding has a bigger impact.
Okay. Well,
I think
you made your view clear.
to leave it off in terms of where we're at. I mean, our position is that the 4%, or if I just call it for shorthand, the 4% option, as it were, and the 4.5 million option is not one that should go into the 106. We're very much trying to obviously secure a bilateral 106 with Swale. And if, as a consequence of this discussion, Swale require that, Swale tell us that that is a requirement of them entering into the 106 bilaterally, then that is, we think technically that is a further option that could be included into the 106, although we resist it both, well, in principle and also on the numbers. But we'll have to take it away and discuss it with Swale. If it's something that they require, then that's fine. Otherwise, unless they require it, it won't go into the 106.
Well,
the Secretary of State's
I can't really see why you don't really need it in the Section 106. What you need is some sort of provision that the Secretary of State can, if the Secretary of State feels it's appropriate, change the contributions.
That need to be in the 106. That's what I mean.
Yes, but that can be a clause. You don't have to put it, if you're worried about putting it in terms, it's just the principle. The Secretary of State is empowered, therefore, to ask for more money.
But the Secretary of State would also at the same time have to understand the implication.
Well,
We'd have to include the knock-on effects for affordable.
Yes, of course. and that would have to be changed as well. But that's again a figure, isn't it? 4% or
Yeah,
10%.
that's what I'm saying. It's
so
that.
basically, the Secretary of State has the overall power, and I've seen that. I think that's perfectly doable. You don't have to set it out in terms that 4% and 4.5 million or 10% and 1.5. I don't think. But again, I'm not a lawyer.
Sorry, ma'am. Are you kind of thinking about a sliding scale of so like 4%
Well, actually,
up?
I mean, there's no evidence in any other. It wouldn't really be a sliding scale because there's no evidence that any other figure really. It's sort of all or nothing, really. I would have thought. I mean, otherwise, if it's a bit of one and a bit of the other, it doesn't really satisfy anybody.
That's the problem. As I see it, I thought the options really were either 1.5 or I'm just round figures, 1.5 or 4.5.
Yes,
4% or
Yes.
or 10%.
Yeah, not anything in between.
No, but that's what I'm saying. As I'd understood it, the drafting would have to actually specify that those are the two options, whatever they, whatever the specific numbers are, which we could do. I think in theory that's obviously doable. I'm not saying it's not doable for us to do that technically. But I'm saying we would object to it, particularly because it actually doesn't represent what the council's asking of us, and they're the other party to the 106. And if in the end the Secretary of State doesn't like the solution that we've reached with the council on an agreed basis, then the Secretary of State's going to have to think about whether to grant planning permission.
Yes, I know.
So
But that's a bit dramatic, isn't it?
well, I mean, is it though? I mean, well, I mean, it's.
We're trying here to problem solve, aren't we? We're not sort of like trying to sort of.
We're trying to problem solve, true, but I mean, if we take the approach to each of the obligations that we would then be taking to this, which is to say that if anyone else, Rule 6 parties, members of the public, have different views about choices that we've agreed with the council for many, many months and which have been the basis upon which we've done the whole inquiry, it's going to be a very tricky 106 because people always have different views about the way money can be spent.
But the acute care the acute care one in particular was one that has caused, the most debate, really, hasn't it? I mean, the other ones are, I would have said, health versus affordable housing is. I mean, that's a national issue, isn't it, really? It's not just in our little bubble here, it's outside in the big world, isn't it? But, it's not up to me it's your Section 106, and if it, Secretary of State will have to deal with it of whatever's presented. So, I'm going to leave it at that, I think, and see what emerges. Having lit the fire, stand back and, yeah. All right, because I don't.
We would like to see it in there.
Right. Okay. Well, there we are. All right. Shall we move on now? I mean, obviously, we will need to know what's going on, but I think I'm not
pretty quick. I mean,
putting you on the spot, so I think you need to think about it.
We thought we had an agreed position with Swale and the NHS, and they've literally just changed it that minute.
Well, it's probably because I prompted a bit.
Well, you might have prompted, but you didn't force them to. And now we do need to know where we are as we're closing the case.
Of course we do.
On Friday. We are closing on Friday. Others are closing sooner than Friday. So we're going to need to talk to Mr. Digan as to what the council's position is, because not now, but I mean...
Yeah, I understood the council had a position that was established that Mr. Digan made clear that they wanted 10% affordable housing.
Do you want to talk about it
we'll
outside
take it
the
out.
inquiry?
We'll take it outside
I've
the
made
inquiry.
the point.
Yeah, understood.
Now I'm going to just carry on. That's the inspector's prerogative. So, okay, thank you. Now we've talked about where it's to be sited. I don't really want to go over that again. And we've done that. Yes, if the owners, if the owners build the facility, then obviously the contribution wouldn't be necessary, would it? It's only if the.
Are we talking about the Northern only facility?
Oh well, yes, I am at the moment. Yes.
Correct.
Yes, that's correct.
Yeah, the contribution is for the NHS to build it. Yes. Yeah. Okie dokes.
And we're talking about primary care. Primary community.
Yeah, and I'm getting off acute
Away
care
from
now.
acute care. Good.
Yes. Right, okay. Thank you. Where are we now? Yes. If you could turn to page... Oh, they're not page numbered. It's still in the definitions, and it's sort of like the penultimate page of it. Healthcare Land 1 and Healthcare Land 2. I didn't have a plan. Is there a plan? Mr. Keegan, you forwarded some of the appendices, but it didn't include a plan. LCO1.
That's correct. We hadn't collated all the plans as yet, but they're all inquiry documents. So this particular plan would be, I believe it's from the development structuring plan.
Core documents.
I see. Okay. It might be development structure plan. I mean, that's not a plan that's to be... Oh, yes, I see. That's only an illustrative plan, of course. It's not a parameter, one that's to be approved now, but...
Yes, that's right. It's the development structuring plan, which refers to LCO1, which we're proposing to append to the 106 agreement, although, as you say, it's not a plan for approval.
No.
Hence the reference to indicative.
So what does it mean then, a marked LCO1 subject to approval pursuant to a condition? Because we haven't got any condition.
Well, the plan is subject to approval pursuant to condition.
Well, it's not subject to approval because it's not a plan that's to be approved, is it?
The development structuring plan, I believe, is a plan that's approved pursuant to condition. It's beyond the strategic phasing plan.
You might need to check the conditions, ma'am, and just check whether... I know the green spaces, but I don't know about the development structuring plan.
I don't think it is. I thought it wasn't. Hold on a minute. I've got all the conditions somewhere here.
So we need to check. There should be a future approval. We just need to double check the conditions.
So it's shown indicatively on the development structuring plan, which we're proposing to append to the 106 agreement, but its actual final location will be subject to approval pursuant to a condition in the future.
Yeah, but I'm just worried there might not... Whether we've got a condition in here.
The development structuring plan, as I understand it, identifies the development parcels, and I think that there's a condition which requires a strategic phasing plan to be submitted for approval, which will identify both the key phases and the development parcels.
Okay. Strategic phasing plan, A6. Is that it?
That's correct.
Just looking at that now.
Right, okay, that's fine then.
Yeah, we should include the expected board sequence of delivery of development within those key phases and development parcels.
Okay.
Just while we're talking about land, could I just raise a point that obviously when the NHS, if they elect to build the facility, they would need to have serviced land transferred to them. I just wanted to check whether there was or could be a definition of
I think, doesn't it not say that
service
somewhere?
anywhere.
Does it not say it somewhere?
I know we'd had it in earlier drafts. I'm not sure about this one.
Because that will be the master developer, won't it, that will do the service plot.
If that's not in there, I think it could be added to the definition of disposal requirements.
I'm grateful, thank you.
Where are we? So you'll say it will be added, did you?
That was always the intention and agreed position, so if it's not in there, it's just an error in the disposal requirements. It just needs to be added in.
So that's the first one on the sheet, disposal, yeah?
Second one down, disposal requirements.
Oh, yes, okay. All right, thank you. And the healthcare land 2, that seems to refer to the same plan, but actually, if you're looking at the larger site, it's actually LCO1 and LCO2, isn't it? I don't think LCO1 on its own is big enough. Is it?
LCO 1 I had understood was, in the version I'm looking at, is 0.61 hectares.
Yeah, but that won't be big enough for the bigger facility, would it?
I think we need a
No.
0.58.
Yes,
Oh,
that's
I
under
see.
0.61,
Sorry. Oh, right,
so that would
okay.
be big enough.
I see, okay. Okay. Okay, thank you, yes, okay. I'm now coming on to the actual covenants. 2.1.1, isn't it the occupation of 30%? Because 70 and 50 make more than 100, don't they?
It's 30% of the contribution at 50% occupations, then the balance, so 70% of the contribution at 70% occupations.
30% of the healthcare contribution, this is the acute one, in full prior to the occupation of 50% of the dwellings.
Yep.
And then the balance of the healthcare contribution prior to the occupation of...
So essentially that's 70% at 70%. So 30% at 50%, 70% at 70%. To put it in a, so 2.1.1 and 2.1.2 are phased in the same way.
I see, okay. Okay.
We probably need a mechanism in there for actually saying when the local authority should know when the overall numbers reach.
Yes, that will be addressed by
It's in
way
the
of the
notices.
notices provisions in, I believe it's Schedule 2, where we need to ensure that there is a notification given for every trigger in the agreement. We haven't yet filled that in because we're just waiting for the document to be completely finalised, but we will ensure that that is covered.
Okay. So if it's if the owners are to build it, then the trigger. Can you just remind me of what the trigger is in terms of occupation? When will it be built?
Are we referring to the northern only
Yeah, we're just doing it
facility
on the
now?
north at the moment. Yeah.
Okay. So this is prior to the occupation of 475 dwellings for the northern only facility.
Right. Okay. And then if it's the contribution, then that will be 200. Yes.
That's correct.
Transfer of land and transfer of contributions by 200.
Transfer of land. I see. Right. Okay.
And we're adding the serviced element now.
But if the NHS are to build, then if the NHS are to build it, then it will be the transfer of the land 200. Yes.
That's correct. Yes.
But that's as far as it goes. So there's nothing after that, is there?
They get the land, they get the money, And there's no further restrictions, correct?
No. But I suppose there couldn't be really, could there? Okay. But if the developer is to build it, then there is the trigger.
We felt that was necessary.
Well, I think so,
Yeah,
definitely.
Ma'am, on that one, we know locally that just to even build an extension on a existing GP facility takes at least 5 years. So the NHS may have the land. I see that there isn't really any assurance that this facility would come forward if it was in the NHS's hands.
Well, the NHS aren't subject to the Section 106. They can't be tied to it, you see.
Okay. So just so that everyone understands. Okay, thank you.
Yeah. One would hope that it would be delivered.
I suppose it doesn't instill confidence because I think we feel the NHS here are not really defending the need for their facilities as we would expect. And how can we be assured as a community that this would come forward in a timely fashion?
Do you want to respond?
Yes, we've made sure that we can get that land, service land, and those monies in sufficient time to get the facility both planned, tendered, and built by the trigger of 475. And we've looked at the trajectories we've had from the developer, and we've calculated it, we think, robustly. So that's why we're content with what we've entered into.
Okay, well, let's hope so. But, Mr. Gearing, I think from what you've said and the evidence and so forth, it would be your preference to build it, wouldn't it?
I think so, yes. I think that's what we've said. I think it comes down to as well whether it's a combined facility or the smaller facility, because then if it's a smaller facility for the north only, there could be potential reliance on other Section 106 funds as well. So I think if it's a north only facility, the likelihood is the NHS would build it. Whereas if it's a combined facility, it would be a master developer landowner-led project. I think all the options are built in, which was part of the discussions we've had with the NHS to keep that flexibility and ability to make those decisions at the right moment.
Okay.
I think it's fair to say that it would be the NHS's preference for you to build it as well, but it relies on that extra capital.
But if you're waiting for more funding, supposing it was to be just the northern site, and you're waiting for there is this funding gap, but you said that you were confident there was money available.
Yeah, to deliver the northern facility, clearly to build an 800 square metre facility, the funding that the northern scheme is providing isn't enough, even if it was going to the NHS or if it was being developer-led.
No, you said that.
So there would be a reliance on the funding from other Section 106 agreements from Swale. You said
that you thought that was there anyway.
I know there's a number of schemes. I don't know the exact amount of funding that's been collected or is controlled in agreements. There are a number of permissions, and we have asked for that information, but it hasn't been shared.
Yeah, to the best of my knowledge, Mum, there's not £3 or £4 million sitting in unspent 106 funds to top it up.
At the moment.
At the moment, yeah.
Okay. Right. Sorry, Miss Keegan, were you wanting to say something?
No.
Okay. Yep.
I don't know if it's appropriate to ask, actually, to say, is it possible to see where these other funds are coming from? So where are these other S106 schemes, and can they be detailed?
don't know who would like to answer that.
Do you mean currently held Section 106 funds?
I'm just asking, so you've identified there's a short gap. Where is that short gap filled from? And it's been alluded quite properly that it's coming from other S106 agreements. So the next logical step from that question is, what S106 agreements is that additional money coming from?
We can provide information on all the Section 106 agreements that have either already contributed or are due to contribute in the coming years.
Okay, I'm actually trying to help in protect the NHS to make sure that you've got enough money coming in
we can
to make sure that you are fully funded for what you want to build in the Northern scheme. That's what I'm trying to help. I'm trying to be protective because I think it's what you're trying to do is brilliant, but to do it you need dosh. You need hard cash.
Absolutely. And as Mr. Brookside said, I don't believe there is sufficient to fill that gap at the moment. So, but we can provide that information.
We'd have to have it quite quickly. Okay, thank you. I can't remember, how much was the funding gap? 4 million, did you say? Something like that?
It's about 3 million.
Yeah, it's between 3 and 4 million, today's prices, ma'am.
Okay. So I think that on the northern side, oh, hang on, something else. Oh, yes. For the northern side, that's all the questions I had. And I haven't got much for the southern side. So should we just go through that and then we'll just pick up if anyone else has anything they want to raise? So just looking at the southern side, I'm only just... right, okay, so... in fact, I don't think there is actually. So just if it were to be on the Oakwood site, just looking at the development structuring plan, where on the Oakwood site would it be? 'Cause there are a few. I think you said around at LCO. Was it?
Sorry, give me a moment.
4. That would be the biggest, wouldn't it? Would it be LCO 4?
Sorry, just give me 1 moment.
I don't think any of the other ones are big enough, are they?
We've identified OLCO1 and OLCO3 on the structuring plan.
And I think all of it depends on the area of land. So the area of land secured is for the larger parcel, as you suggested, which is the LCO4. However, it also comes down to the number of stories that the facility's built over. So although we can secure that larger land requirement, and that is secured within the parameters, we've done a bit of modelling exercise ourselves, and it may well be that one of the smaller parcels would work if you built a 3-storey facility, depending on how many car parking spaces need to be dedicated or how many could be provided elsewhere in the local centre. So we're confident that from a parameters point of view, there's a large enough parcel that meets the minimum area for the NHS. And I think the NHS are happy with that as well. But I think when we come down to detailed design, there may be more than one of those parcels could be suitable.
Have you got anything to say about that?
I think the only comment we'd make is we wouldn't want it spread across 2.
Agreed.
Which was originally suggested, and yeah, we'll need to look at the design in due course as to the...
Anyway, that's the point of detail, isn't it?
Ma'am, access is a reserved matter. The indicative plan does show like an access way between the two plots.
Mm-hmm.
Obviously, it wouldn't be ideal to spread them across two sites with a road between.
Are you looking at the structuring plan? I think that's isn't that the that's highway green space. Is it? I think these greens are very difficult. Highway green space, yeah. So it would imply there would be a roadway through there, wouldn't it?
But it is an indicative plan, and access is reserved, so we could look at the position of the road.
I mean, there is a little bit of pink, isn't there? LCO5 up right at the north of the southern site, isn't there? Which, that's much nearer, of course, the northern site, isn't it?
It's probably too small, Ma'am, for the super facility, as it were.
I don't know if Mr. Gearing said it could be over more than one floor, then it could be possible.
Based on the NHS's request for 0.58, it is too small.
Mm-hmm.
I think when it comes to detailed design, 0.58 is a very large area if you build over more stories. But that's what their request is, so we've identified the parcel that can achieve that. If there was a way to have a bit of flexibility, I think we would work through that at the time. You wouldn't want to have a single story facility, for example, taking up a lot more land, or you don't necessarily need to have all your parking as well. And if there's a communal car park in a local centre, that would serve a doctor's surgery as well. So it comes down to some of the detailed design of a local centre.
Well, and sustainable travel, of course.
And sustainable travel. Again, you don't want to build a huge car park if you've got buses and cycling and walking routes. So.
Okay. Right, well, I think that's all the questions I had on that, but has anybody got anything they think's not been raised? Miss Bonney?
Well, it's picking up on your sustainable travel point, because I think, from what we experience elsewhere, is that the public transport pickup points do need to be in close proximity to that facility.
Yeah.
Because the memorial definitely doesn't have any connections, and the parking is a complete nightmare where you're reliant on roads outside, etc., or other. And this will be a privately run estate, so they're not public car parks. These will be estate car parks. So I think all of those combined, and I agreed it does need to be all on one site, but certainly serviceable from public transport. And not just within, because if this is to properly integrate with the communities around it, it needs to be not just serving itself, but the wider communities.
Yeah.
And if I may just say, the communities including the northern site. So if you're going to have a larger southern site with a larger NHS facility, it needs to be accessible. So geographically, this is now becoming, it's no longer walkable from the northern part of the site to walk down to pop in for a doctor's surgery. You will have to rely on a car or bus transport.
Or cycling?
Cycling, yes, but it's quite I'm thinking of an older resident in their 70s or 80s. Are you asking someone how they're going to get down?
Well, you're not going to have more than one facility anyway.
Absolutely not.
So, it's got to be somewhere that's, I mean, some people probably would have to drive to it, I would imagine.
Absolutely.
But,
I don't want to go over the evidence. We've got our sustainable bus strategy, and we've
Yeah.
gone through how that would connect
I
up
know.
the local centres, and all the facilities are within 400 metres of, all the houses within 400 metres of a bus stop, etc., etc. If I may, there was one thing I was going to raise.
Yes, of course, Mr.
It's
Gearing.
slightly going back to acute care, so I'll try
dear,
not
right.
to go into too much detail, but
Right.
the NHS did submit a late letter, CD 100.87, on the 17th of October, which obviously post-dated all the evidence we've given.
Shall we
on
turn
this.
that one
Yeah.
up?
So if we turn that up, that's the letter to Mr. Digan about the NHS achieving a acute care contribution on the Northfleet Harbourside planning application.
Hang on a minute, sorry. Okay.
We obviously had a look into the letter and the application that they mention there. And I don't know if we should respond in writing or not. I kind of thought it was useful to bring up today, given the NHS are here. I just wanted to set out that 3 points really. That firstly, there's a different policy position in the respective local plans, and how that's referred. What reference is given to local healthcare facilities or just healthcare facilities. When you look into the appeal documentation, there's a letter on the file that confirms there's a reduction in the primary care sum, and then therefore a contribution to acute care is provided. And then thirdly, if you look back through the application file, the NHS's original request was for over £20 million. Then it was for £6 million, and they agreed a negotiated position. I think it was agreed. I discussed this with the NHS on a call of around £3 million, which is obviously substantially lower sum per unit than being requested on the northern and southern applications. And I don't know if we need to respond in writing, but I thought it was useful to raise this, given the letter was sent in by the NHS as an example of securing acute care contributions. It's also not secure because it's a Secretary of State decision, so we don't know if it's secured. It's an agreed position between the applicant, the council and the NHS on a public inquiry at Northfleet, but there's no decision on that.
Oh, I see. Right.
There's no decision yet.
Anybody want to say anything about
Ma'am, the NHS agreed a lower contribution on the back of that development on the basis that it had recently secured around £7 million worth of SIL funding from Dartford Council to support with the expansion of their ITU department.
SIL funding, was that?
That was SIL funding, yeah.
The SIL funding from a different local authority, though, I think.
Okay. Well, are you going to respond or not?
I think we can put that as a short note. It's essentially set out what I've just said as a response.
I think we could probably deal with it in closings. I think rather than a separate note. Now that Mr. Gearing said what he said, orally sort of thing, we can cover it in closings.
Okay. Is there anything
Yes.
else?
Madam, could I just say on that obviously we brought it to the inquiry's attention because the developers have been saying to us that developers don't agree to acute care contributions, full stop, and of course there are various developments where they have done. Obviously there was quite a notable, very large one at Barnet, I think Millbrook Park, for example, for Finchley Hospital. And so we just wanted to make it clear that obviously developers do agree. Obviously that developer is content that there is a policy basis for it, and has agreed to basically take on that acute burden that some of the residents will cause from that Northfleet Harbourside development.
Just to say, there are obviously cases in the country where developers, for whatever reason, have agreed to pay sums towards acute care. We've never suggested that there are none, or if we have, well, I didn't mean to, because there are some for reasons of their own. But what we absolutely don't accept is the fact that there are cases that the NHS have been able to point to where developers have just decided to, for whatever reason, take it on. Has any bearing on the arguments that we've made on SIL compliance for these contributions? And that's the point. Obviously, it circles back to where we got to in the evidence that you've already heard and the correspondence.
Right, okay, thank you very much. Well, so I think that we've come down really to, I think the primary healthcare we've sort of we've understood and we've discussed, and everybody's, you know, had their say. The thing that's a bit of a sticking point is the acute care, isn't it? And the extent to which the lower sum for the northern site would be acceptable to all parties, and whether the Secretary of State ought to have the ability to, if he was so minded, to agree to a higher acute care contribution at the expense of affordable housing, and accepting that the council and the applicants have agreed what's in the deed. The NHS now are saying they would like to have the full amount, and we have got also local representations, including the Rule 6 parties, the parish council's Rule 6 parties, who also you know, put their view in. So it is a matter the Secretary of State is going to have to consider, and it's really up to you how you address it or don't. However, whatever happens, it will be dealt with in some way or other. Is that fair enough? Okay. Right, well, I think if you wanted to, you could, unless you've got anything else you wish to say about the healthcare contributions, Ms Thomas. Quite happy for you to all go, if you want to.
Thank you very much indeed. No, I would obviously don't want to repeat what's in the evidence and don't get to closing. Obviously, the local authority will close in relation to the active arguments that's there.
Okay.
Obviously, if we need to be still in the loop for any redrafting that's done, clearly. I appreciate there's not much time to do that. However, we will, you know, make our best endeavours to look at it, as long as we are able to comment on it if we feel we need to. Thank you.
Yes, I mean, bearing in mind that obviously there's not going to be any more opportunity to discuss this now. I think this is the discussion. So, you know, the Secretary of State will have to take any views and do with them what he wishes to do. But just that, the numbers that you said that you could give us of Section 106 contributions, perhaps could you do that in the next sort of day or so? Would that be possible?
Yes, I'll do that this afternoon.
Could you? That's lovely. And if you, I mean, just send it. If you send it to the council, they can just distribute it, or send it to the programme officers. In fact, that'd probably be even better. Is that right? Good. All right. Well, thank you very much. So, did you want to go now, or do you want to wait till? Yes, because I know you've got time pressures. So, so just while the NHS representatives are just gathering their things, I think we could possibly do one of the other things on the agenda, and we perhaps could turn to Schedule 4, which is the ecology one. Should we just have a quick look at that? Please. Right. So on the northern side, this is page 41. On the southern site, is thank you, Ms. Thomas. And I only had 41. Now, this is something we have already discussed, so I don't want to go over back over all the discussion, but the only thing that I found that was outstanding, as I've said on here, is that there was talk about the wardening provision to manage the ancient woodland and country parks. Now, this is different from the wardening contribution for the in connection with the European sites, which was a different matter. And I can't find any provisions in here.
Yes, we've reflected on your query about that, Mum, and that is actually picked up in the open space and sports facilities schedules. So I appreciate we're going to turn to those later, but just for reference, there is a open space management plan which is secured pursuant to that schedule, and that refers specifically to the provision of wardens.
Can you just point me to what page? Schedule 10, is it?
It's Schedule 10, yes, and the definition.
Thank you. All right. Ooh, is that which side? Which one are you look?
It's page 75, so the submission version of the Northern. We're looking at the Northern.
Yes, let's try and stick to the same document.
And 75 of the Southern as well.
Page 75. Okay. Hang on a minute. So, where am I looking? Open space management plan. Am I?
So it's 77 on the Southern one in the definition of open space management plan, and it's 75 in the Northern one in the same definition.
Okay, whereabouts is it?
Yeah, it's a slightly chunky paragraph, but it's about halfway through the definition where it refers to the need for that plan to demonstrate the funding of the measures set out, including the provision of wardens.
Yeah, I mean, it's a bit sort of tucked away, isn't it? I mean, I thought the idea was that we were going to have some, you know, I mean, there's going to be, obviously there will be a cost involved with this, with the funding of a position of somebody. I would have hoped it would have been a sort of separate.
It's also picked up in the stewardship schedule, pursuant to which there is a requirement to submit an asset phasing statement on a key phase by key phase basis, which details the assets which will be submitted to the, transferred into the stewardship vehicle. And again, that repeats that reference there to the need for that to cater for the provision of wardens, where that transfer involves the relevant open space for which those wardens are necessitated.
Okay. Okay. Okay, well, that's where it is. So you think that's sufficient?
We felt that was sufficient to make sure that that was picked up, and that the specific reference to wardens was designed to address that requirement.
Okay.
Ma'am, if it'll help, there has been some amendments to that, so it is not hidden away in a clause partway down. The clause is broken up a little bit more now.
Is
So,
it?
yeah, not.
Yes, so we've obviously gone straight into discussing the NHS provisions. I think it's worth saying that we submitted these versions in time for the submission deadline. There's been some continued negotiation on elements of the schedules since that date over the past 2 weeks, as both parties have undertaken proofreading amendments. As I flagged in my cover email when sending the submission versions, we'd actually only received the open space north schedule on the night before the submission was due. So we put that schedule in because we understood that it was broadly in line with the southern one, which we were comfortable with. But Swale have reviewed that schedule in further detail since submission. We don't think that we haven't physically had time to submit you anything further because we received another version of it only yesterday. So we are comfortable, however, that we can talk you through changes which do not, in our view, go to key substantive matters, and we can clearly submit a further version after this session which picks up in track changes, any additions, which we can also supplement with an explanatory note. But we're comfortable that the versions you've got before you contain the key matters of substance, and anything additional we can with Swale's solicitor, who's been leading the drafting on that, explain anything to you.
Yeah, I mean, it just makes me a bit nervous when you say there's, further changes, because, the whole point of this session is for everybody to actually see what's actually in the documents. I mean, okay, so picking up typos, I agree, that's one thing, but I want to be satisfied that they're not substantive changes that are now being proposed.
I can assure you that the absolutely best endeavours on our part have been expended in trying to ensure that the submission versions put to you were agreed and in final form. That hasn't been possible in all cases because of the timing for receipt of certain schedules, and I'd invite Swale to perhaps comment on that, because it's not entirely in our control. But we feel comfortable that we can explain in the sessions where any points of note need to be drawn to your attention.
Okay. I mean, are there substantive changes?
I could.
Well, let's see what the council has to say. If you've got.
Ma'am, I wouldn't say there was substantive. There is more detail added, but I wouldn't say that there's anything substantive to what's there. Obviously, we're asking for more detailed information. I think most of the changes that are made are just in relation to the definitions as to the level of the detail that we require to be submitted. And I think, in fairness, it's not the developer's fault. I take responsibility for this part of it. But on the northern site, what we'd done is we'd lifted what was on the southern site and put it in the northern site, subject to that we were still negotiating that and getting instructions on that. So it's not the developer's fault on that. It's our fault.
I don't want to assign anybody.
Yeah, no. So I appreciate that. So there are subtle differences between the two sites, obviously.
Yeah.
So, for example, there isn't a country park on the northern site, but there is a design brief that accompanies. No, there's a parkland.
There is a country park. I mean, there is.
Yeah, I think on the southern site it's referenced as a country park, whereas I think on the northern site it's a parkland, which is largely remaining as it is, looking at the plans that have been submitted. So, whereas obviously the country park on the southern, there's a lot more detail going into that. Yeah, what had gone in on the northern site was effectively what was in the southern site. So it has been adapted to reflect the northern site more accurately.
Are you talking about just the open space bit, or all of it?
So I'm just trying to look at the. So see.
I mean,
I'm looking. So yeah, it's the open space management plan, which is largely changed. It's just been more clarification to make sure that actually one was submitted, because we had referenced it throughout, and then it'd been picked up that there actually wasn't a requirement to submit it. So there is some drafting that's gone in to require.
Okay,
that.
well, okay. Well, we'll be coming back to that, won't we? A bit later. I mean, I have to say that, you know, really, the length of time that is, you know, between, well, even just the inquiry, but let alone anything else, the inquiry, you know, we've been going since March. I just can't quite understand why these documents are still being negotiated, really. They should really have all been finalised. I mean, you know, Pin's advice is really now that Section 106 agreements should be put in right at the start, you know, but I understand that in this case that's, you know, probably can't happen, but, you know, I would have thought by now, really, we're in the last week of the inquiry, we should have a document which we can all know is, you know, what's going to actually be in the, you know, the signed version, but, you know, it's like a lot of other things, that everything seems to be evolving all the time. But anyway, all right, well, you'll have to just point out things, I think. Yeah, Miss Bonnie.
Yeah, and I totally agree with you, Mum, because this is like pin the tail and donkey for us. So we haven't seen whatever has been going on between the council and the applicant. And the devil is in the detail in this, as Stones Farm Country Park and the Sang clearly demonstrates that if there is a cock-up in drafting, we, the community, end up paying the price. And we would have liked to scrutinise whatever the current version is, but here we are in a public inquiry, however many days in, and we've not been able to see. The applicant should have had this sorted with the council ages ago. I mean, one instance, if we're talking ecology and open spaces, is we can't really see where the references are to Sang and its implications. Perhaps they might like to
well, we're not
enlighten us.
Yes. Can we just?
Are you referring to the Sang matter you raised about a week and a half ago, the first time?
No, I raised that in landscapes fairly early on in our evidence. All the way through, I've been consistent about Stones Farm and its impact. The fact that you've denied to answer and address that and read the documentation is your problem, I'm afraid.
Well, anyway, can we not talk about open space just at the moment? I mean, I was really, my only question on ecology, which probably will take us up to lunchtime now, is about this warden provision. I think you've answered it, thank you. I would prefer to see it a little bit more prominent, but it is in there. So that answers my question, really. Okay. Right, okay, thank you very much. So, ecology, apart from that then, so I don't know your name actually, because you haven't really, yeah. What's your name?
Sorry, ma'am, it's Russell Fitzpatrick.
Right, and are you the council
Yeah,
solicitor?
I'm the lawyer.
Yeah, okay.
I'm one of them.
One of them, right, okay. Yeah, I mean, is there anything else in ecology that I should be, or we should be looking at then, that's been changed, that's material?
Nothing, ma'am.
Right, thank you. Right, well, I suggest actually now we'll break for lunch then. Okay, is that all right? And then we're going to go on to affordable housing and viability. And just to say, we're not going to review the viability evidence, okay? Absolutely not. Okay, so anyway, there we are. That's what I've got to say. So we will have a break then till 2:00 because that's when our people who are joining virtually are going to be available. All right, but then we will probably carry on a bit later if that's all right with everybody, given we had a late start. So I don't think we have to be out of here early today, do we, Mr. Digan? So we might have to carry on till about 5:30, 5:45, something like that. Yeah, okay. All right. So the inquiry is adjourned till 2:00. Thank you. Can I just ask everybody, please, to sign the our schedule there, which tells me your names and all the rest of it, because there are some people who haven't attended before, so it would be helpful to have everyone on there, please. Right. So, what time have you got to go for your meeting?
So we've been discussing that. So there's slightly crossed wires on the meeting. So we've been back in touch. Which sits with me. It's my fault. We tried to move the meeting forward to do it last week after your request, and then we had a response back from Natural England saying we could maybe do Monday morning, and I missed that email. So we then lost the slot this afternoon. I've had email correspondence with them, and I've been speaking to Mr. Dygan, and we're going to try and call them in the break as well.
Right.
The good thing is we had to get the note in on the SANG first, and we've sent that to Natural England as well, our note response.
Right.
And I've asked 2 specific questions of them, which is what one of their emails back to me asked, which is, do they consider it is SANG themselves? And if they do consider it SANG, how would they want to see a potential additional SAMS payment to make up the shortfall? So there are only 2 questions for them, and we're just going to try and work through those.
If they consider that's appropriate.
Yeah, whether they consider it appropriate, and if so, how it would be achieved.
So when are you going to talk to them then?
They've just come back to me and said 3 p.m. tomorrow.
Yep.
And it's just, obviously we'll be in here at 3 p.m. tomorrow. But if it's helpful, we can...
We could have a break.
Yeah, 3 p.m. tomorrow. That's good news.
All right, Julie, good.
Apologies, and thank you for mentioning it this morning.
No, that's all right. Sorry you missed your slot. Right, so we've got Miss Dickinson and Mr. House. He's not. Oh, did he? Oh, sorry to hear that. So you'll be dealing with. You'll do your best, right? Okay, fine. So it's just Miss Dickinson then, isn't it, that we're... I think she's got to be let in, as it were. She's there, I can see. And somebody else.
I can hear you.
Oh, can you? We can't see
Yeah.
it. We can't see you.
My camera's on. I'll turn it on and off again.
Oh.
Yeah, I can see me.
Oh, can you? That's nice. We can't.
And I can see your screen.
Oh, right, okay.
I don't know why it's not coming on. I don't know if it's a privacy setting on your side. I don't know.
Well, it'll be the backroom people that are dealing with it, I think, probably. So, okay. Well, we can carry on. You can hear us anyway, so can you?
Yes, thank you.
Yeah, okay,
Yes.
fine. Good. All right, then. So we're going to go through the Schedule 11 of the North, it's the North, and Schedule 13 of the South, which is the Affordable Housing and Viability Schedule next. And the way, I think I'd like to do it a similar sort of way as we did the healthcare, basically just going through the schedules and picking up points that I wanted explanation on. And then obviously if there are other factors, then people can come in and talk about those. So just looking at the first part, which is the interpretation. So in terms of the affordable housing dwelling mix, should it be said, do you think, that this is to be informed by the most recent SHMA?
We've had a discussion with Swell Borough Council about this, and this approach of having a range of dwellings set out in a table is informed by Claire Dickinson's evidence, and particularly the need for certainty on the part of the developer when bringing forward the particular housing phases, such that we know what the parameters are to ensure that there is a healthy mix. Otherwise, the developer could be put in a position of having to deliver a disproportionate number of certain sized units at particular times. So we felt it's very important to have some parameters around that, around the dwelling mix set out in the 106 agreement. We didn't feel it was necessary to refer specifically to the SHMA, but it draws from Claire's evidence.
Right, and because I mean, obviously, it's going to be over quite a few number of years, especially the southern site, and there will be updated SHMAs and that sort of thing, won't there? But so I mean, will that play into it at all or not?
There is ability to have another mix as may be approved by the council, so there is some flexibility there should things change. But we feel that the parameters are sufficiently wide that there's quite a lot of tolerance in there already.
Okay, do that.
Yes, so I mean it has been a point of discussion because the timeline over which the development would be built, you assume in 20 years the need may change. So this having minimum and maximum numbers or parameters for the different size of units has been sort of carefully considered, because it's sort of like, do you set those parameters now or do you wait to see what the need is in 15 or 20 years? So that's discussed with the borough's affordable housing officer and with the senior management team, and the view is that actually this approach is acceptable in terms of setting the parameters within the table that you see.
Okay, thank you very much. Okay. Right, we can see you now, Ms Dickinson. Right, do chip in if you have anything particular to say at this stage. So, affordable housing target then. Now, in the northern site, we have this... hold on. Sorry. Yeah. We have a 27.7%. In the southern site, we have a choice which the Secretary of State's asked to adjudicate on. So am I assuming that the council is accepting the 27.7% for the northern site?
No, ma'am. What we would require is the 40% to be referenced in there. It could be a blue pencil clause so that the Secretary of State can adjudicate. The reason that it's not shown in the drafting on the northern site is the applicant doesn't accept that blue pencil clause.
And to be clear, we also don't accept it on the south, and whilst it's in there, our covering note when we sent it in indicated that position wasn't agreed. We don't feel it is appropriately a blue pencil matter. So our position is that it should be 27% in each agreement.
Why don't you think it's a blue pencil matter?
Shall I ask Claire to step in here, or shall I?
I don't mind. Ms Dickinson?
Sorry, Ms Dickinson?
Yeah, I'm happy to make some comments. I think that when we went through in preparation for my evidence, it was very clear that the 40%, that there's no basis for it. It's an arbitrary figure. So it's not something that is referenced anywhere in the strategic housing market assessment. Indeed, the SHMA actually makes reference to 30% being an appropriate target against the 27.7. So there's no reference anywhere to 40% as being a need. And so we go back to the NPPF, which is very clear that the target should be based on need. In the case of Swale, we've got this very complicated DM8 policy that's being interpreted in different ways by different parties. It's really important that authorities aren't given carte blanche to bring in any target they require for review mechanisms without any evidence basis for it. That would be incredibly damaging for boroughs across the country, and the 40% has no basis in need. That's obviously was addressed in my evidence, not wanting to go back through evidence in any way, shape or form, but our position is that the the borough target should be based on what the need is for, which is the 27.7, was updated in 2020 and is very clearly set out and is consistent with the NPPF.
So why then is the in the southern site, why is 40% still in there on an agreed section 106 document?
It's not. It's just because the version that we had sent to us by Swell included the two different options, but our cover note sending that made it clear that it wasn't an agreed clause, but Swell wanted it to be shown in there so that you could see the difference between the parties.
Ma'am, you've heard and seen the evidence, and there's been cross-examination on this point. Yeah. So the borough's not going to sort of repackage or reiterate the evidence, and within this forum, it wouldn't be appropriate without sort of reopening things to hear new evidence or repackaged evidence in relation to it.
No, all I'm asking is, in one of them you've got the two options, in one of them you haven't.
I think it's because the council didn't come back to us on the Northern Affordable Housing schedule until, I think, Friday, possibly, this last Friday,
so are
after the deadline, so they didn't add it in.
Are they going to be the same then?
They were. I understand from what Mr. Dyker's just said that they should be the same from their perspective, yes.
Ma'am, if I may.
Yeah.
Yes, I appreciate on the northern side that a lot of the information that came in after the submission date.
Okay.
But with regards to that split between 27.7% and 40%, that was in the draft. It was afterwards but after that was submitted, that the developer took a stance that they were not going to accept any blue pencil clause in respect of that, and they would be prepared not to enter into the agreement on that basis. It's a slightly different. The council's approach has always been blue pencil because this has been an evidential issue, something there for the inspector to decide, and then that's where we come from. Sorry.
Well, yes, but what I'm saying is they're different. One's different from the other, so surely they should be at least be the same, shouldn't they?
Yes, I think Swell's position is that they should be the same with both in, and our position is that they should be the same with 27.7% in.
Well, you've got to decide because it's a joint document, isn't it? So how's that going to be resolved?
Well, I think
you can't just sort of split it and say, well, we'll have one with one and one with the other, and that would be good enough.
No, I think the council's position is it would need to be, the 40% would need to be reflected as a blue pencil clause for us to be able to sign the document or to agree it.
Right, okay, we're a bit of an impasse there then, isn't there?
And then our position is that
you'll only accept the 27.
Yeah. And
how are you going to resolve that then?
So we've had
another thing that
we've had discussion. Sorry,
a bit crazy, I think. Really, why don't you just leave it to the Secretary of State? I mean, if it's not in the evidence, surely you can accept that the Secretary of State is going to make a rational, well thought out decision. I mean, I just can't really see what the problem is personally, but still, there we are. If you're not. I mean, the evidence, the Secretary of State's got to decide. I know you come very forcibly and say there's no evidence for it. Well, if there's no evidence, then presumably the Secretary of State will say there's no evidence. But, that's not what we were told in the evidence, if you see what I mean. So, anyway, it's got to be resolved, doesn't it?
It does, and we have had discussions that what would the implications be for the 106 agreement as a whole if that impasse existed.
Well, I think it's ridiculous personally, but still, I mean, it just doesn't seem to be sensible. It just seems that you're both taking these stands, when I can't really see why there's a need to do so personally. But anyway, it's not my document, so you do what you like. But it's got to be resolved, hasn't it?
It does need to be resolved, yes.
They've both got to say the same thing, basically.
I suppose the discussion point was if we don't reach an agreed position on the 27.7 or 40, notwithstanding what you've just said, is what are the implications for the agreement as a whole? And we've had discussions at whether there'll be a bilateral for the remainder of the agreement with a unilateral for the affordable housing schedule.
Yeah, I suppose it does. I don't know if the healthcare thing was another thing that you disagreed on, wasn't it? Whether that's another... Anyway, okay, fair enough. Well, okay. Anyway, yeah, okay. Okay. And in terms of the affordable housing tenure mix, this hasn't got a range, has it? Do you think that that might change in the, in the future, or are you happy to put that in as sort of fairly definite?
We're comfortable with it, ma'am, being set at the 60-40 split.
And the applicant's happy, Mr. Dickinson, with that?
It's been very consistent over many years.
Yeah.
And I think as well the scale of this scheme means that in the context of delivering to a mixed balance community, etc., that having certainty is incredibly important when it comes to delivery of engagement with RPs, and also it gives the council reassurance in terms of the emphasis on social rented meeting their housing waiting list requirements. So we think it's an appropriate approach.
Thank you. Now, obviously, social rented dwellings are generally, and I don't know whether in this market, but generally speaking, quite a bit cheaper, aren't they, to rent for people than affordable rent. And I'm just wondering whether there is any provision for to ensure that there is a reasonable amount of social rented dwellings in the mix, or whether that has to be left to the council to...
No, I take your point, ma'am. It's just we don't have a really strong policy basis for securing a specific amount of social rent as opposed to social and or affordable rented.
Does the framework not help us at all?
No, not as far as I'm aware.
What has the... I mean, Mr. Gearing, in terms of what the applicant would do, because obviously it's you get more, you get more value out of affordable rent than you do out of social rent, don't you?
You do, and I think obviously I don't want to go over the viability evidence, but we agreed with the council a proportion of open market value for the affordable units. I think it was around 56%, and I think that was based on assumptions over affordable rent and intermediate, without looking at social rent.
Sorry, you said 50%.
I think and this is obviously from memory, so apologies, but I think the viability work that was discussed between Mr. Orse and Mr. Mitford-Slade relied on a broad assumption of value for the affordable units as a percentage of open market value. And that would have been based on a assumption over that mix. I don't know if Ms. Dickinson's able to help there.
Do you know, Ms. Dickinson?
I think we can have a little bit more faith generally in the competitiveness at the moment of social rent comparative to affordable rent. It's important to remember the affordable rent is inclusive of service charges, whereas social rent is exclusive, so they're closer together than it may initially appear. When you look at the value of social rent, as in what someone can pay, an RP will pay you, it isn't that materially different at the moment because there's a huge amount more support financially and otherwise for social rent to RPs, and the agreement on CPI plus 1%, etc., for rent growth has meant that RPs have become a lot more settled about what they can pay for social rent. So the disparity, I don't think that we should be thinking this will automatically mean that it's going to be affordable rent. I think actually social rent is very competitive now, comparative to the affordable rent.
Okay. I mean, I don't know, you know, affordable rent's 80%, isn't it, of the...
Up to. Yeah,
Up
it's
to,
not
yeah.
necessarily at, it's up to, and a lot of the RPs wouldn't necessarily charge at that level, and it is inclusive of the service charge. It's not, you can't get grant funding under the current Affordable Homes Programme for affordable rent. You can only get grant funding for social rent, and generally RPs wouldn't want to mix. They wouldn't generally deliver a proportionate social rent and a proportionate affordable rent in one block. They would have one tenure type. So if I had to make a call on it, I would expect these homes to be social rent where we are at the moment in terms of where the funding programme is, where the support is, where RPs are delivering. But it can change, and it's really important that given the duration that this scheme covers, and that we will have changing regimes, that we do have that flexibility in terms of where the government are guiding and saying the financial support and the focus should be, as well as what the preference is locally.
Okay, fair enough. Yep. Anybody want to say anything about that?
From a community perspective, social rent is preferable over affordable rent.
Okay.
Thank you.
Okay, thank you very much. Right. Oh yes, I don't want to go into the viability at all, but on the next page there was the benchmark land value. It was just that they're different, and I can't remember in terms of the viability. Are they different for the north and the south?
No, they're not different. I think this is just a drafting error. We can make sure that that's corrected.
What should it be? Do you know?
In terms of this is 100. I thought it was.
You thought
Should be 100,000 as it is in the southern one.
But
Right.
it's the per hectare. Should be 110. 247,110.
Well, it needs to obviously be the same as what we were told in the viability work, doesn't it?
I'll double check that, ma'am. That was the advice that the financial consultant gave me.
Can I just check that that's agreed between the parties? Because some parties were shaking their heads just now.
It's not a case of not being agreed. We know it's either 100 or it's 110. There was just a discrepancy. There was a discrepancy between the north and the south in the drafting, and we made an amendment, I think, to the north one, which kind of, I think, flagged it. The inspectors just simply picked that up. So it's not that we're in disagreement. It's just that
We're both in agreement. We're both in agreement on the figure. We just can't quite recall if it's 100 or 110. So we're going to go back and double check it and make sure it's agreed.
And whilst we're at that point in the document, just above it, the BCIS median house builder rate, I thought when we talked about this in the viability, it was the lower quartile in Mr. Spilsbury's written evidence.
Certainly the advice I've been given by our financial consultant is that it should be the lower quartile.
So that correction will be made.
Well, no, that's not agreed on our side. Our viability consultants understood that they'd agreed the median with the council's viability consultant for the southern scheme. So we were surprised to see the lower one appear in a draft sent to us on Friday.
So it's difficult, Mum. The financial consultant's in hospital at the moment. He was taken in on Sunday afternoon, so otherwise he would have been here to explain.
Yes.
But he was quite adamant on this point when I spoke to him on Thursday last week.
So you think it should be lower?
Yes, ma'am.
We agree.
And that's what, well, Mr. Spilsbury, of course, was Kent County Council, wasn't he? Wasn't he? Yes. So, and you think it should be,
The median.
so how's this going to be resolved? Or is this going to be another separate schedule as well? Or it's the same one, isn't it? It's all affordable housing, I suppose.
It's complicated because we had an agreed position on the south which says median, and then the updated drafting for the north that came in on Friday said lower on the north. So we were surprised to see a difference between the south and the north, and that literally has only arrived at the end of the week.
So as it was explained to me by our consultant, it's the nature of the BCIS and the information that goes into informing that is often from public sector organisations. So quite often the costs are reflective of developments which are not as efficient as the private sector, which is why, in his view, the appropriate part of the BCIS is to use the lower quartile rather than the median.
Okay, well, that's the reason. But
My experience wouldn't be that, I'm sorry. My experience would be that the median, when you're trying to use it in the way you're trying to use this, it's really important to use the median because we have increasing costs that are coming in terms of environmental and other building regulation requirements, which are higher than they would have been historically. And the BCIS is looking backwards, and I thought that was discussed in all of the evidence that I heard on viability from everybody. It was acknowledged that it's backward looking, and therefore to use the lower would seem to me to be misaligned with reflecting where costs are at a point in time.
To me also it feels at odds with the idea of a placemaking premium and building, driving up quality, and yet the council is now suggesting we should be building to lower costs.
It's being realistic, ma'am, as to, for viability purposes, reflecting what is likely to be as close as we can get to the actual costs of construction.
Well, I mean, when you say actual construction, I mean, again, that depends on what quality you're looking for, I suppose, doesn't it?
Is it best that we? It's difficult, isn't it? But do we need to speak to our? Obviously, our viability consultant isn't here, nor is the council's.
Yeah.
It's not ideal, but that we only received the difference on Friday.
No, fair enough.
I think
Okay,
we can look to resolve it, and it's been aired as an issue.
Yeah, it needs to be resolved, doesn't it? Thank you very much.
If you're still on that same page,
Yeah, going up it again.
development costs means all actual costs incurred or estimated costs.
Oh, hang on.
That's page 89 on the north.
Yeah, I've got development costs, yep.
Yeah. So that's on the introduction there. I suppose our question is about the reasonableness of those costs, and when we go back to the definition, that includes the costs of this inquiry, no doubt, marketing costs, etc. Is that fair and reasonable to put in that clause?
Sorry, I'm a bit...
So it says here means all actual costs, and if you go to the definition right at the front of this section, talks about actual costs.
I see.
It means open book basis, independent verification, those reasonably and necessarily incurred and achieved in the ordinary course of that development. That's everything. So that's all their marketing costs, the inquiry costs, everything thrown in, kitchen sink. Is that reasonably to be included.
What you think it should or it shouldn't?
Well, we don't think there should be reasonable development costs, but that's not throwing the kitchen sink in it of everything, and maybe the council might want to check with their viability consultant.
I think the two viability consultants have had a detailed discussion of the definitions in that regard, because the same applies to the south and the north, which comments were sent in on later. But in terms of the costs, that is a standard and reasonable approach to take into account the types of costs that we've got itemised there. I think that's acknowledged by the council's viability consultant as well.
Certainly, he has looked at these definitions, ma'am, and on a line-by-line basis. He hasn't raised an issue in relation to that. I'm not a viability expert. I can't ask him to explain why he finds it acceptable, but he hasn't raised an objection to it.
And also, I think those actual costs are in relation to the items identified actually on the viability review mechanism. So in the actual template that has to be completed and submitted. So I don't think it is a free-for-all. It's actual costs of those that are identified in the agreement.
We're talking about you're talking about the review mechanism now, are you?
That's what the actual.
Yes. Yeah. Mm-hmm.
That's what it all relates to.
Yeah.
Unfortunately, what it is that there's a lot of definitions here which don't go to the obligations themselves, but rather relate to the template.
Okay. Anything else on that?
Oh, my next comment's on 94.
Okay, well, hang on a minute then. Let's just see if there's anything else. Hold on just a minute.
Ma'am, I do have in relation to the northern scheme,
Yeah.
and I'm just looking at the definition of affordable housing base provision.
Hold on. We're going right back now. Affordable housing. Oh, yes. Okay. Hang on. Yep.
So point B, it talks about 6.08%. What the council had looked to do is to increase the affordable,
Sorry, hang on a moment. You are... Sorry, where are you? Affordable housing base provision.
Page 88
Yeah.
of the Northern Agreement.
87, page 87, yes?
88? Well, certainly mine is 88, and it has the definition
We're
of...
looking at the same document, that's all.
It's on page 87 of the versions that have been submitted.
Okay.
Anyway, yes, and so which bit are you looking at?
I'm just a bit concerned that I might have a different version to yours.
Oh,
Can I
yeah,
have a look
so
at
am I.
Yeah, that's right. Yes. It's the version that I'm looking at, ma'am, is not the right version. So please, I'll work from...
So is this all right then? You don't want to raise this?
Yeah, no, I don't want to raise it.
All right, okay, fine.
What's the 6% of mine?
Okay, that's fine.
Yeah. But I was just, I don't know.
Right, okay. Well, I don't know if anything's... the next thing I've got is housing delivery scheme, residential reserve matters area. Is there anything before that? Page 93 on the northern site.
I just want to check, if I may, ma'am, on plots, because...
Where are you? Can you just tell us where you are first?
Sorry, apologies. Page 95, definition.
Oh, you're after.
On the north.
Plots, yes.
I just wanted to check where we were with making sure that they were...
Oh, goodness.
We're talking about service plots.
Yes. Well, this brings into the...
Maybe we're... Okay, I'll let you carry on.
Well, no, I mean, basically, it's the problem of what I wrote in my notes of how the language used in the Section 106 agreement does not accord with what we were told in the evidence or the language that we've used in the conditions.
Right.
For example, key phase is not as used here. Key phase is something below the phase that's shown on the phasing plan. That was what I was told and we've agreed. So, but here it seems to think that the key phase is exactly the same as the phasing plan. I don't think it is. Well,
Yeah, I think it's fair to say that we've taken a slightly bespoke approach on the affordable housing and viability schedules by reference to what we're terming housing phases.
yeah,
and
yes, you have, that's true.
it is different, but we do take your wider point, and I'm not sure whether now's the right point to discuss that, but
Okay, well,
yeah.
you've talked about housing phase. Yes, I sort of think that is. I'm not quite sure how that actually ties in with key phase. It seems, but we haven't really got to it yet, have we? But your point, Ms. Bonny, was when you talk about plots.
Yeah, what service costs, what normal costs.
Yeah, I'm not sure what plots means. Does it mean a serviced parcel, which can be, we're told, up to 100 plots, individual plots? I'm not quite sure. I mean, as far as I understand it, the master developer would be providing the services for the house builder to come in and, the roads, the drains, the water supply and all the rest of it. So, and then the developer comes in, and it might be that there are 100 development plots in a development parcel. I don't really know what. That's how I understood it anyway.
Yep, so the definition of plots relates to the triggers for the viability review, which is triggered on plot sales, which is the service plots which are being sold to the house builders.
Or if they were unserviced, it'd still be plot sales. Be the sale of the land.
The sale of the land to support the plots which are being delivered to the house builders.
So when we're talking about plots, are we talking about development parcels? No.
We need this clearly set out somewhere.
One plot would equate to one unit.
What a mess.
So the plots are actual units of equivalent to a dwelling, effectively a plot for a dwelling.
Okay, I see. Well, I think it could be.
No, you can't. Sorry, that's a better term. I think as long as have we got a definition of plot?
But you see, plots of land could be the development parcel, because that's a plot of land, isn't it?
I see your point. Ultimately, we need to know within a plot that's sold how many dwellings would be accommodated within that.
Well, we can't know yet, because we don't know what's going to be. No. I mean, somebody might say we want, I don't know, a development parcel for 100 homes, or they might say we want one for a bigger one. And I'm presuming they then come to you, and then they basically give you some money, and then you start servicing it. Whatever size
if they were service plots, yeah. I mean, for the north, it's not structured in the same way.
No, it isn't structured the same way in the north, I agree. In the north, it seems more conventional and easier to understand, I think.
Yes.
But we still run into this problem of terminology. But I think it does need to be made clear, even in the north, and that's what we're on at the moment, what plot means. I mean, how does that work at for example, if it's a part of the commercial part, one of the local centres? Or is it just residential?
It's just residential, but obviously you may have some residential units within one of the floors of a local centre, so that could be incorporated at the same time. I think we know what it's meant to mean and what it's meant to do. I think we just need to maybe just speak to Swell and see if we can clarify it in a slightly clearer language, picking up on your concern of between plots of land and plots being a plot for each dwelling.
Well, I mean, on the south side, for example, do we have the same thing? Do we refer to plots?
If I may, I think the definition of plots used here is only relevant in, when I say two places. One is in the definition of development costs, and bearing in mind that the purpose of the viability is to assess to work out whether or not there's any surplus or any money left over to deliver affordable housing. And then the only part that it's referenced for a trigger is actually for the trigger of the viability review. So 51% of the plot. It's not used anywhere else in the agreement or in that schedule.
What did you say the first one was? Sorry.
The first one was in, just let me flick up to it a bit, sorry. The definition of development costs, which then obviously feeds into the template, the viability template. And then it's used in presently I think it's page 101, paragraph 1.2. I mean, it's not to say that plots isn't used elsewhere in the agreement, but I'm talking about in relation to this schedule. The word plots is, it feeds into the development costs, right, for the purposes of the template, and is only used for the purposes of a trigger as to what triggers the viability review.
On gross development value, you're running off theoretical numbers and not actual land receipts. Just to point that out.
Are you talking about plots now, or are you talking about something else?
Well, in that you were talking about development value, but there's also a gross development value, and that's off a theoretical appraisal basis, when actually I think you should be using what you've actually got in land receipts provided by the developers.
Well, I mean, we're just talking about definitions here.
Yeah, sorry, I'm a little confused. We're talking about development costs, the definition.
Yeah.
And then in development costs J is where the term plots is, the defined term plots is used. My point is simply that's used in three places. One is to define plots. Two is in this definition of development costs. And three, for the trigger, to trigger a viability review.
And I can see that it actually isn't used in the southern site, I don't think.
On the southern site, we have the term service plots, and that's to do with the point that you alluded to about the difference in the approach to the viability review mechanisms for each development. So the service plot is a term which is relevant to the south, where we've got the service plot appraisal and the master developer appraisal. And then, as you say, on the north, it's slightly more straightforward and simple. So that's why there's just this reference to plot rather than said of the service parcels of land.
So is a service plot is a development parcel? On the southern site, is it?
No, it wouldn't be tantamount to that. It would be the plots that are, an individual plot is for an individual dwelling.
Just to be, I know there was some discussion about this, going back to the viability evidence that we've all promised not to go into, about terminology. And Mr. Mitford Slade said, as you will see if you go back and have a look, that in his cash flows and in his master developer appraisals, unit meant the same thing as plot. When he was talking about plots, he was meaning individual homes, or land for individual homes, not something else that he was referring to as serviced parcels, which, do you remember, there was all that stuff about he'd made an assumption that maybe it might have 100 homes, etc., all of that stuff. Okay. And that formed the basis of his master developer appraisal. But that's not going back any of that, because that was all cross-examined. But just on this word plot, it was used consistently in his evidence as essentially synonymous with unit or land for an individual unit. He never used plot as a as a sort of umbrella for a bigger collection of units.
So a service plot in the southern site is the same as a plot in the northern site, is it?
Other than it's serviced.
Yes. Spatially, it's the same.
House.
I think it's to tie in with the template, because the template talks about service plots, because for the northern site you've only got one tab dealing with the plots, whereas for the southern site you've got the service plots and you've got the master developer costs.
Yes.
So
That's exactly right.
I think that's what might be, as I say, it's rather a use of terminology for the section 106 rather than tying it across to the condition.
Yes, I don't think this particular piece of terminology has relevance to that broader question that you've raised, Mum.
No, okay, fair enough. Yeah. Okay. Reserve matters area, residential reserve matters area, is that again something that's unique to this schedule?
Yes, that's right. That's a particular term used in this schedule, and it's really to provide more granular details of the dwellings and affordable dwellings that are going to be coming forward for particular areas of land for which reserve matters applications are submitted.
So we shouldn't try and equate it to anything other than what it says.
Quite.
Yeah, I think it's the case that the planning permission will deliver the units. The agreement says how those units will basically be divvied up, if you want, between open market, affordable housing, extra care, etc.
Mm-hmm. Okay. Is there anything else on?
Yeah, I've got something on page 94, index linked definition.
94. Wait, are you on the north side? Or
Yeah, north, sorry.
94. Index link, yep.
It refers to, on the second line, the Knight Frank Farmland Index or other farmland index. We think this should be an RPI ONS 1.
Sorry, you think it should be?
The RPI ONS index, not the Frank Knight one.
Could we possibly ask why that's the case? Because this is quite a technical area, and the viability consultants have discussed quite specifically the appropriate index and landed on that as an appropriate one for the purposes of this viability review mechanism.
Yeah, we wouldn't have chosen that as quite a very narrow farm. I think, as someone described, it's like throwing a dart at a board, because it's quite a lumpy index, whereas the RPI ONS one is a more fluid one.
Well, I mean,
It's agreed between us and the council.
So it's, ma'am, it's because most of the sites are farmland, we felt that a farmland index would seem to be most appropriate.
The index used is obviously linked to the subject matter of the contribution which it is applied to, and so that's why there are specific indices used for specific contributions in 106 agreements. And as Mr. Dygan says, this is considered appropriate for indexing the land parcels that are subject to the viability review, and it's specifically designed to reflect an appropriate one for that purpose.
Can you go back to the thing?
I'll check with my consultant and come back to you.
all right. Just a minute.
I mean, I thought, wouldn't that be an evidence issue? And the Rule 6 parties didn't give any evidence on that. They withdrew all their viability evidence.
We did not withdraw our
They didn't withdraw their viability evidence. Well, they relied on the council, but
Sorry, they no longer relied on, incorrect
I
language.
think that's a bit different. Yeah. Okay, I'm just going to see if there's anything I've got on definitions before we just go to the clauses. Just hang on a minute. Right, nothing on there. Just a sec. Right, just on the southern site, the master developers return. Oh, hang on a minute. What's this? Oh, sorry. Just hang on a minute. There is a few things. Right. Okay. In terms of the extra care dwellings, I just wondered. It's a bit out of date, isn't it, to have extra care dwellings for eligible individuals of age 55, isn't it? I mean, I think this was something must have been decided, eons ago when people only lived to about 70 or something. But, I mean, come on,
We were having this discussion in our office because one of my colleagues is in his early 50s.
Well,
and I was
you
threatening
might
to
be
move.
a young office.
So, we were having this exact discussion about it seems a bit slightly out of date. Normally,
It was
65.
65 in the previous draft, and we were asked to reduce it down to 55, and I can't quite recall the basis for that.
I think that was KCC. It was a KCC request to tie in with their, I think it was your policy.
It's the accommodations, the affordable housing accommodation strategy, social housing accommodation strategy. I think we changed it to I think it also includes or such other individuals with demonstrable eligible care or support needs to cover.
This is an actual age thing, isn't it? It isn't for people necessarily with, it's just extra care, and it's got an age. It doesn't say anything about people with disabilities.
Ma'am, it just says age 55 years of age and over by default, or such other individuals with demonstrable eligibility care and support needs as agreed with the county council on a case-by-case basis.
So exactly. So if you had care needs and you were under 55, presumably you'd be covered.
Correct.
Yes.
That's correct, ma'am. Yeah.
So it just seems. I still think it seems a very out of date sort of thing. That's all.
I think technically 55 has been the historic figure, but quite a few have priority to those over 65, but allowing a minimum age of 55. I think recognising early onset dementia, etc., that these facilities can be appropriate for some younger individuals, but priority is often given to over 65s.
It would be quite. Anyway, I'm not going to argue about it, but I've just always thought.
I think that's how we felt. We were happy with 65. The council came back with 55. We didn't really agree to it, but we weren't going to fight over it.
Okay, well, I think time's too short to worry about it. Okay. Okay. Next thing. What's that? Oh, I'm presuming all these error references are just things that have cropped in. Yeah.
It's the automatic cross-referencing, which we'll have to get right in the final version.
I was just interested in the gross development value in the southern site. It said all public subsidy. I don't, obviously it's not an evidence matter, but what does that actually relate to?
Do you want me to speak?
Yeah, please.
I think it is in the event that an RP was to, it's likely that an RP that gets engaged with could have a wider programme, a wider delivery programme, and as part of that they may be able to draw down on some public subsidy or grant funding to be able to support their entire portfolio. And I think if the developer is in receipt of some affordable housing grant, it's important that that is acknowledged as part of a revenue income stream. So it's more likely for the review to then be triggered. It's just making sure that any sources of revenue are picked up.
I see. Thank you. And then we've got a housing phase, haven't we? So I'm right in saying that this is a unique term, is it, just for this schedule?
Yes, that's correct. They're designed to be large phases encapsulating on the south a minimum of 464 dwellings, and attached to those housing phases would be these overarching housing phase delivery statements, which provide a look forward as to what's going to come forward in the housing phase to which they relate, and also a holistic view as to what's likely to come forward in subsequent housing phases, and taking into account delivery on earlier housing phases where they're submitted for later housing phases, and then drilling down into more detail beneath those housing phase delivery statements is the schemes for the residential reserve matters areas, which is when you get into a more granular detail as a precursor to the subsequent RMA applications.
Okay, thank you. Yeah, the housing phase plan then. Oh, is that what you just said then? Is that what you were talking about, the housing phase plan?
Yes, well, the housing phase plan is a plan that would be.
We haven't got that yet, have we?
No, you haven't got that. We could circulate that. We have a version drawn up which indicate it's linked to the an overlay on the housing phase on the phasing plan, parceling attaching numbers of units to the different parcels shown within that.
It allows for revisions, doesn't it?
It does, yes.
So if I just a sort of technical point, if the plan that's attached to the agreement is revised, would that not need some sort of deed of variation? Because it would be part of the. It would be part of the commitment, wouldn't it, in this particular document? So if you vary it, would you be able to revise it without?
You would, because it's not an approved plan, which would be. Oh, sorry, apologies. It would be able to be revised pursuant to this, because it's a plan that is going to be appended indicatively to the 106 agreement, and could therefore be subject to a revised submission under the 106 agreement. It's not an approved plan on the face of the planning permission, which would need to be subject to an amendment to the planning permission, and in turn a variation to the planning agreement if it were to be changed.
I see. Okay. Oh yes, in housing phase delivery statements B, you've got this 40% crept in again here, haven't you?
Yes, that's a slightly different point here, because this is talking about the levels within each housing phase. So the 40% that we've been discussing earlier in the session relates to the site-wide level of affordable housing. This, on the other hand, relates to the level in each phase, and we're saying that for each housing phase there is a minimum level and an upper level, so that there are some parameters on what would come forward on a phase-by-phase basis, so that the council has assurance that there's a minimum level in each of those phases, and likewise we've got the comfort that there is a maximum level. But then you take into account the delivery across each of those housing phases, and that feeds into the overall level of affordable housing, and that is an overarching matter that has to be complied with, and that's where the other 40% is an issue.
But you haven't got the minimum there. It's not set out, is it?
Yes, so that B also refers to not less than the minimum level, and the minimum level is defined as 15%.
Where's that
in the house in the southern one? That is definition on page 113, and then there is
I see
an
that.
equivalent in the northern one, where we have also have a minimum and a maximum.
Oh.
Sorry, it's slightly different on the north. No, because we haven't
I
got the
don't think
housing
you've got-
phases. Apologies, it's slightly different on the north. Yeah, because of the smaller scale of the scheme, we don't have that same structure. We go straight into the residential reserve matters areas.
So it can go up to 40% and as low as 15, but it's got to even out,
to the baseline.
which is what?
So the baseline depends on whether the acute care contribution is accepted, the Kent Downs contribution, whether that is accepted. So there are various baselines depending on what the Secretary of State considers about contributions such as acute care and the Kent Downs.
But do we come into the basic problem that, or perhaps we don't?
There is a definition of the affordable housing based provision, though, that sets out those different options.
That's at page 106.
In which one?
Of the south.
And 87 on the north.
But I think for the purposes of the maximum and minimum, it's only the south we're looking at.
Just a minute. Sorry, the affordable housing based provision, where's that again, did you say?
It starts at the very bottom of 106 and moves over onto 107.
Oh, I see. Okay, I see, yep. Okay. And then we've got the 40%, yeah. Okay. Master developers return. So master developers return is 15%, and that presumably is what was agreed in the viability work, was it?
Yes, ma'am.
Okay. Right, we've dealt with that. Okay, I think. Anybody else got anything on the definitions? No. Okay. So in terms of the provisions then, right, okay, I think yes, in terms of 4.1.5, oh, sorry, north. No more than 50% of the open market dwellings shall be occupied unless and until the provisions of subparagraph 5.1 have been complied with. And I think that is the, this is the trigger, isn't it, for by which time the affordable housing has to have been delivered. Is that right?
I think it should say 4.1 rather than 5.1. This subparagraph 4.1. So it's the
Oh, right, yes.
yeah, it's the requirements to deliver the affordable housing in accordance with that paragraph. It's an error in the cross-reference.
Right, okay. So presumably, well, it says, shall unless and until the, sorry, as may be agreed, oh yes, or such other amount as may be agreed. That's what makes me slightly nervous. So does that mean then that there could be more market dwellings being provided before any of the affordable housing comes on stream?
It does allow that flexibility, yes.
Is that the council happy with that?
Those are my instructions, ma'am, yes.
I don't think that's very satisfactory from our point of view.
I mean, why would it? I mean, this is a. Is it a what area does it? Is this just a general provision for everywhere, or is this?
No, it's related to the residential reserve matters areas. So it's saying that you can't occupy more than 50% of the open market dwellings in any of those reserve matters areas until the affordable dwellings, which are required to come forward in that area, have been constructed and PC'd and also transferred to an RP. I suppose that flexibility could be useful in a situation such as now, where there's difficulties in finding registered providers to take on the units. It could just allow some special circumstances in limited situations where that control is with the council to agree. So it's in the council's hands as to whether or not they're willing to flex that figure.
You got anything to say about that, Mr. Dickinson?
Always. I think this is very much a catch-all situation. Shouldn't happen, but I just think we're a little bit nervous because of the 500 units that the council have got at the moment, that they're struggling to be able to get our Ps to contract. And we just need to know that there's leverage back from the developer side, that the council's being flexible. So it will give us leverage. So for example, if they're putting a really restrictive list of RPs, or we've got an RP that isn't for them on their current list, and we're saying, yeah, but this person really wants to take it, it doesn't give the council control to stop the market housing being occupied. They have to be reasonable. So it's a process to two ways of negotiation to make sure the homes get delivered. It doesn't give them a right, the developer a right to press on. There has to be agreement, but it's really important that both sides are motivated to come to an agreement. And circumstances at the moment are really challenging, and you know, we saw in the publication last week from MHCLG and the GLA saying the absolute priority is to get house building and to maintain it building. It shouldn't all be just about affordable housing. So this makes provision, gives flexibility, but doesn't give control to the developer.
I thought we were in an affordable housing emergency.
Yes, we are, exactly.
Well, it doesn't sound like it. If there are 500 dwellings not being occupied. Or...
It's not that they're not being occupied, is that the RPs are really struggling because of the enormity of the viability challenges that we're facing nationally, and costs going up, and RPs are having to invest a lot of their money into building safety standards. They've been struggling to be able to get finance because they didn't have a finance agreement on the rents. They didn't know where rent increases were going. That a lot of RPs have contracted a little bit and just are re-looking at their business plans. So they haven't been buying the stock that is needed. It's caused a real issue. It's not that it's not required, it's not that it's not a priority, but the RPs and their business plans have been struggling. So it means that some boroughs are having to widen the net of the RPs that they would normally use, bring in new RPs or new investment. And it's really important that boroughs are open to that. And this borough's really struggled, and it's a problem nationally that RPs have been contracting. So it's not that there's not a housing crisis, it's that there's a crisis in terms of being able to get the right money in the right place to enable things to happen.
I see. Okay. Anything? Anybody? Okay, so anyway, it's got to be approved by the council, yes? Does it say somewhere?
Yes, that's right. It's in the council's hands to approve that flexibility.
Right. Okay. Okay. I think that's all that I've got on that. Just a minute. Oh, what's this? Hold on. Oh, right, it's again about the, yes, okay. Okay, anybody got anything else before we go on to affordable housing viability review? Okay. Now, in terms of the northern site, I'm assuming it's only one review, isn't it? Not reviews.
The council would like 2 reviews
On the northern side?
on the northern site.
Oh, well, that's not in here, is it? It's just one.
As the applicant's preference is for 1, and we obviously have a disagreement in relation to that.
Oh. Well, someone needs to explain that then, because I'm not in here, is it?
So the council's view is the timing of the reviews needs to be relevant to capture market cycles, so markets fluctuate over time. So we feel that if, for example, a market cycle is around, say, 5 years between the time that an application would get consent and allowing time for land assimilation and the Northern Relief Road to be built and so forth, that in actual fact 2 reviews over the life of the development would be needed to be able to capture the changes in the market. If there are upswings in the economy, then we feel that on 2 occasions through the life of this development would be appropriate to measure the viability.
So you're saying one should be 5 years after the planning permission, is that what you're saying?
We've actually looked at occupations as opposed to years.
Right, well, so...
Russell, can you remind me what we...
Because at the moment it's just half way through, isn't it? The
we
plots.
say, 30% of the service plots for the first, and for the second and final review, we say 70% of the service plots.
And when you say service plots, just to be absolutely sure, but I know what you mean individual dwellings. A plot of one dwelling plot.
Think.
For one dwelling.
Yeah, it'll be the land, not the actual house on it.
No.
Yeah.
But actually, they're not really using that model, are they? They're not using a master developer model.
Yeah, as I was saying it, I was thinking, hold on. So, it should be plots. Sorry, that was what we do, because there's a similar issue on the southern site. So I think what's happening is there's been I'm going to say there's been cross-contamination in the drafting. I think the northern side should be saying plots, the southern side service plots. Simply not because they're related to anything in the conditions, as we've already discussed, but rather relevant to or specific to the agreement.
So what would it be? Would it be when 30% of the plots... Well, surely it would have to... Why not just have it on occupation? 30% of the houses are occupied.
Why don't you say every 500?
Well, whatever.
Because I suspect there would be an awful lot of
Ben, would you be able to, Ben, do you want to just come in on explaining why you wanted the viability reviews to be based on plot sales as opposed to occupation of dwellings?
And we're talking on the north here as well.
Just the north.
Just the north.
Let's just do the north.
It's although the viability work isn't put together on a master developer model, which was explained through the viability evidence, ultimately we're still going to be delivering the strategic infrastructure, and that will be funded through plot sales, not occupations. So we'll end up in essentially the same position, that we need to have the certainty over values on plot sales to fund the infrastructure, as in the Northern Relief Road, essentially the Northern Relief Road. So although the viability appraisal work carried out by Mr. Slade and agreed Mr. Orst wasn't on the same basis with the master developer, it was all on the basis that we would still, and the way that 106 is structured is we still have to fund and deliver the strategic infrastructure up front.
I see.
And that's based on plot sales, and if we're selling plots we need to know what assumptions there are over development costs and value, which is to do with the overall affordable housing amount.
But
So
we don't
it does drive us back into that same position as plot sales, not occupations.
So do we know how many plots there are?
In the north, so 1,250, and then
But
we would
so-
probably sell. We
So
would
it's
sell
residential plots.
residential
Residential
plots.
Right, well, I
So-
think you need to make that clear.
So residential dwellings 1,250, and we would envisage that would probably be 2 sales, as we've discussed it a number of times, to 2 different house builders or a single house builder. So that's why we've suggested a trigger of 51%, because we believe that is a point by which we would have funded the strategic infrastructure and delivered the Northern Relief Road with the first sale of 50% of plots. Then after we move on to that, we would have a second review which would know the established infrastructure cost by that point from building the road, and allow us then to, if there has been market changes of values as well, that would be picked up.
But the thing is, that there's lots of other things. I mean, you've got the school, which would be obviously on a plot, wouldn't it? And all sorts of other things. The medical centre. So I think shouldn't you say residential plots?
Yeah, I think residential plots would be fine.
Yeah, I think the definition of plots does refer to specifically land for the delivery of the dwellings, but we can make that tighter if need be.
It probably does.
Well, it does. Well, bearing in mind that also dwellings is defined in the front end of the agreement.
Yeah, it does actually.
So
Okay, so it's the sale of 30% of the residential plots. This is what council wants.
That's the council's position.
70%, whereas the the applicants want 51%. Is that correct? So how is that going to be resolved, or is that going to be also in the unilateral?
If we don't resolve matters, that would then be for the unilateral. One of the reasons and this has been discussed with Mr. Daigan, is that if we're 11% affordable, or if the NHS have 4% affordable, depending on that additional clause discussed this morning, if we have a trigger at 51%, that allows enough dwellings left in the scheme to accommodate the extra affordable as well. So you need to have a review that's not too late, because if the affordable percentage is pushed down to essentially 4.5%, and then there's a review clause, we need to make sure there's enough dwellings or plots left to accommodate the affordable housing on site.
I'll discuss that sort of outside of this forum, but if the affordable housing goes down, then there would be less of it.
Well, not if it had to then pick up the difference at the review. So if the base position is lower and then the target is the same, the gap is bigger, and if you've got a certain number of houses left, you've got to accommodate all that, and you can't have a later review, because then you're just moving straight to a payment to the council without delivering it on site.
But if it's going to be, we're not going to get the option. The Secretary of State's not going to get the option of a lower affordable housing provision anyway, if it's unilateral.
Well, I think I need to discuss that, because obviously the point raised was this morning about the responding to the NHS and the 4.5 million, the 4.5%, and how we work through that.
Okay. Okay, thank you. So, we will have in 2.4 then, the reference to master developer would be appropriate, would it? Because you're saying the master developer would be providing the infrastructure, is that correct?
Yes, I think whilst for viability purposes it's not a so-called master developer model, in practice the master developer role will still be undertaken by the promoter, and so it's a term which is used across the two agreements, and there are certain schemes and certain things that are imposed on the master developer across both, notwithstanding the fact that the viability model is different for the two schemes. So they've still got that coordination role for both developments.
Okay. Then I didn't really quite understand what this surplus is all about. And then, of course, we were told that perhaps some of it could go to the... well, it seems that if there's a surplus when the viability review takes place, whether it's on 1 or 2 occasions, then the developer can have 50% of it, and the other 50% goes to, I thought, affordable housing, but obviously it depends on the level it's reached. But we were all told this morning that might be going to the acute care provision. So perhaps someone could explain.
Yeah, well, our position up until today, and our understanding was that the surplus that may be generated from a review would be solely targeted towards an uplift to the affordable housing base provision, which is that fixed percentage pursuant to each agreement, although subject to where that lands. Yes. In light of the contributions secured. And the viability reviews, if they generate a surplus using those different models, would be translated into additional affordable housing on site, and that would effectively raise the base provision up to that target. And the disagreement we have is over what that target should be.
Yeah.
And as you say, it's now been suggested that there could be an alternative option, although we're not clear as to whether that remains Swell's preferred option, because we haven't had the chance to discuss it further to this morning's session. There is a final option, which is that in respect of the final viability review, should the council wish to secure it, they could instead take that surplus as a financial contribution towards them delivering off-site affordable rather than it going on site. But that's entirely at the council's election, and not something that we could decide to do unilaterally.
At present, the council's not a registered provider, but we are en route to becoming a registered provider. So that's a process which is in progress at the moment. So if you looked, for example, over the southern scheme, potentially with a 20-year build-out, it's quite conceivable that some period between now and the end of the development, the council may well be in a position to utilise a financial contribution to deliver affordable housing itself off-site. And that was the thinking for having an either-or option, that for that final review, if there is a surplus, that the council could elect to either look at additional on-site affordable housing, or if in the fullness of time we became an RP and were able to deliver off-site, then a monetary contribution towards off-site delivery may also be a sensible option.
But what about the earlier reviews? That would be all on-site, would it? And what about for the northern site?
That position is the same for the northern site as well. Albeit, yes, there's only what I meant to say was that the surplus would be used. There would be the election in the same way, because there's only one review.
Surplus to affordable housing on site.
Yes, because there's only one. Well, it depends where we land on the numbers of reviews. Our position is there's just one review, and so the position would be consistent across the two. If there were to be 2 reviews, we would say the first review would generate a surplus towards on-site additional, and then the final review would have that same election to go towards on-site affordable or a financial contribution. If we end up with a position where, as we're saying, there should be just one review on the north, then that election would be there from the outset, because there is only that one review, either on-site affordable or the council's option to take a payment.
Oh, I see. So for the northern site, it could be either then, could it? The northern site,
yes.
It could be either.
Yes.
It's the election's up to the council.
If the council don't provide it themselves, presumably they could give the money to another registered provider, couldn't they?
Well, that's the thinking. The idea is to be able to deliver affordable housing across.
No, but,
so, yeah.
But I mean, we were told that by Mr. Keegan that the I think Mr. Dragon said the council's going to become a registered provider, and that on the southern site, because it's obviously would go on for 20 years or whatever, the council will be a registered provider, so it will be able to provide affordable housing in the latter stages. But obviously in the northern site, it's only over 10 years or something, so maybe it wouldn't. So what I'm saying is, if the council's not an affordable housing provider, could the council take a contribution and hand it over to an established
It's certainly an option, and internally our affordable housing officers sort of discussed that is something that might be able to be done. It would just be to make sure that that really is going to deliver additional affordable housing off-site. So I just need to think about what the rules would be if we were to pass money on, how that would ensure, how we would ensure that we secure that the money actually goes towards delivering additional affordable housing, which would obviously involve some sort of agreement between the council and whoever the money was directed towards.
But that doesn't matter for the purposes of the 106 drafting.
If I can also help, I think sorry.
No, go
on. If I can also help, it's not just, it's also towards improvements. So if there isn't enough money which comes out of to actually deliver, then that money can be used to maybe improve existing stock for adaptions, for example. So converting units into wheelchair accessible units, that sort of thing. So there is flexibility given to the council, again, depending on how much pops out the other end, out the meat grinder.
I see.
It's really important that gets picked up in terms of equivalence for units, though, against any cap of affordable housing. You can't just spend that money not on additionality, because otherwise how do we know when we're at the affordable housing cap?
Good point.
Would that be covered by it being the last review? So we make the payment, and then so as it's the final review, we would have reached that point, by that point, pass the money over. Then if the council spends it, essentially our obligations are met.
Or if there's a provision that just allows equivalence to be picked up as a term, that's fine, but it's just really important that that's picked up in the drafting, otherwise it will be missed later on.
Okay. And that final review, so I hear what the two different parties are saying, but the final review, there should be one close to the end or at the end, so at 95% of the way, to that sweeper, so that we end up with a final position based on actuals.
Well, if it was 95%, it would be a bit late, wouldn't it? I should have thought.
Well, if you've got payment.
Well, it wouldn't if the choice was to actually deliver it on site or take the money and go. 95%, there might not be enough land to actually deliver. So
I'm saying that's in addition to that's a final sweep up position. So you've got the monitoring on the way through. So you're two, the council's two.
Well, they're not monitoring, are they? They're actual reviews.
Well, sorry, reviews.
Actually,
apologies, yeah.
So you're thinking another stage.
Well, it's quite a long way otherwise between either 51% or 70-odd%.
But the thing
especially on the larger ones.
Yeah, you have to make sure you've got enough value left in the site. That's the only thing, isn't it?
I think if I could bring
and
Ms.
I think from a policy perspective, there's no policy basis for lots and lots of reviews. The whole principle of the MPPF is that we should avoid having lots of viability discussions in the first place. And therefore
we all cheer that.
Yeah, and therefore, we've seen the real challenge that there is when anyone starts talking about a number, it's been quite difficult during this entire process, and to maintain that is going to risk that everyone's focusing on something quite negative rather than actually positive delivery. And given that you've got the final review that is picking up market changes in the interim, to keep doing reviews just for the sake of reviews, I think is a massive dilution of public resources.
Okay, well, have to have a think about that.
Well, it's not really a dilution of public resources. The developer's paying for it.
Well, yeah, but I
But
mean,
you still need to have the people to do it.
The example's clear that it's a very difficult process to go through. We've had months to try and resolve ahead of this round table session, and through no fault of your consultant, he's ill, but there isn't the resilience there to do it. I've had examples of working with reviews on local authorities that have taken well over a year because they don't have the resources in-house to even recruit the people to do the review, and then they haven't got the staff who are committed to doing the work to then progressing it. It's all well and good to everyone sitting around the table and saying, well, we need 5 reviews or 7 reviews or a review at the end. But actually, when it comes to 5 years, 10 years down the line, actually doing the work, no one's there who wants to do it. We need to build in proportionality and reviews that are there to achieve the purpose and not go beyond that.
Ma'am, we're asking for 2 reviews for the Northern scheme. I don't think that that's excessive, particularly given the
time.
time.
You're asking 2 reviews for that, and I think there are 3 reviews agreed for the southern site. Is that right?
4.
Our position is 3.
We haven't reached agreement yet. And the council originally asked for 5 reviews on the southern site. We had a meeting and discussed 3 with an initial review at around 25% plot sales and a final review at 75%, picking up on the infrastructure delivery requirements relating to the first set of plot sales, and then the final review being at 75% to allow for those additional plots to then deliver any additional affordable housing. And we felt if you have a review at 25% and 75%, squeezing 2 reviews in the middle seems a bit over the top, and it would still achieve the same outcomes. There's no change in outcomes by having additional reviews because the final review will always wrap it up.
So in terms of the southern site then, I didn't realise there was a disagreement. So what's the disagreement on the southern site then?
So with the southern site, ma'am, we've asked for 4 reviews at 20% of service plots, 40%, 60% and 80%.
Golly. That's an awful lot, isn't it, really?
Remembering, ma'am, it may take some time to get through the highway approval regime to build the junction with the M2, the Southern Relief Road. It could be some years before. And it's just, if there are periods of time that go by that represent a market cycle, then we would like to be able to test the viability to see if the financial situation has improved.
Well, how many market cycles do you think there's going to be in 20 years?
Within 20 years, 4 or 5. Depends how long you think a market cycle is.
Well, quite.
5 seems constant. I can bring in Miss Dickinson, but essentially we agree with the council on the first point that it could be some time, but the first review picks that up either way, 20% or 25%, and we're not far apart between the final review at 80% or 75%. So again, these 2 reviews in the middle, we just think a single review we should cover it.
So you're suggesting 3? Okay. And the 5 parishes think there should be 5? Miss Bonnie?
I need to go and ask our viability consultant.
Okay. Well, that better be done fairly quickly, hadn't it? Okay, just going back to the surplus then. So, is it right to say then that, so you have your surplus, however many reviews there are, you get your surplus 50% goes to the developer and 50% goes to the provision of more affordable housing or whatever it goes to. Is that correct?
Yes, this is just experience that I've had in London, and in fact the GLA also recognise this, that there needs to be an incentive for the developer to actually seek to make a surplus. And so if, for example, the council required 100% of the surplus to, if a surplus is identified in a viability review, that it all go to the council, then it removes the incentive on the developer to actually try and make a surplus. So the surplus is therefore shared.
Is that usual, Ms Dickinson? 50%?
Yes, absolutely. Yeah. Well, there's ranges and it varies, and therefore I'm aware of different proportions, but 50% is not unusual.
Okay. Right, okay, thank you. So, in terms of, we just talked about the three-tier viability review that the applicants are asking for on the southern site, which is in 1.2. We're going to hear from the 5 parishes if they think yet another tier should be put in. That's a surplus. So really, I must say, I don't think I've got anything else to say about that schedule. Has anybody else got anything they want to raise?
If no one has, waiting. I just
Why are you going to raise something?
No, not about the schedule, but linked. It was just comes out of a discussion that we were having earlier in the inquiry, and I actually can't remember when, but I do remember Mr. Young was here, so that limits it down. You were raising questions about Section 73, so I'm just raising it because it's affordable housing adjacent, if you like. It's not about the schedule specifically. But you might remember you were asking Mr. Young about the possibility of coming back in to vary in the future, using Section 73 as a mechanism. He mentioned, I think, an appeal decision he may well have sent around, but I actually can't remember whether he did or not. He did. Anyway, that's not the point. The point is just to alert you to the fact that this is actually a live issue in central government thinking, as has been disclosed by the statement that Mrs Dickinson referred to earlier on this week or last from the central government and the GLA to do with housing measures in London. They've announced that a consultation exercise is forthcoming, I think, in the next month or two, so obviously it'll be well in advance of you actually publishing, or sending your report on to the Secretary of State. And one of the things that will be consulted on, we're told, as part of that, is the government's intention, we think, to use PPG to restrict the ability of Section 73s to modify affordable housing obligations through, imposing a new 106. I mean, I'm summarising, but just to I wanted to alert you to it because it was something you asked about, and it does appear to be a live issue in government thinking.
So using the PPG to restrict, what the ability to change the affordable housing, provisions, you mean?
I just missed what you said. Could you just repeat what you've just said? I'm so sorry.
You mean the consultations on using the planning practice guidance to restrict affordable housing provision
to be changed, essentially.
To be changed.
That's the idea. That's what it's only alluded to in a paragraph, so we're not going into it in loads of chapter, but I just wanted to alert you to it because it's a consultation that's forthcoming. We don't know exactly when, although Mrs Dickinson might, but I don't know exactly when it's going to start, but I think it's promised to start pretty soon, in the next few weeks even. You may well, madam, not know by the time you actually send your report off to the Secretary of State what the outcome of the consultation is. No. But I just wanted to, because it's something that you asked about specifically, I wanted to let you know that was on the government's radar. And their current intention appears to be to think about using PPG to manage the circumstances.
Tighten things up.
Exactly.
So you can't change it.
That's the broad intention, it would seem. But as I say, consultation exercise to be undergone. So we'll learn more in the next few weeks after the inquiry is closed.
Right.
Yeah. Whilst we're dealing with, sorry.
Yes,
Hello.
Sorry, yes.
Just on this point, I think there is, as you will have seen in the front end of both agreements, a Section 73 clause, a sort of usual Section 73 clause, which deals with the fact that the agreement will apply to any Section 73 permission that's granted, unless the council, in approving that Section 73 application, decides that the term should be different, in which case a new obligation would be required. So pretty standard stuff, but obviously what's not in here is we had some further discussion on that clause following Mr. Young's submissions, and one of the things that two things that we sought to include in that clause were an acknowledgement that certainly from KCC's perspective, that firstly, where a Section 73 application is made, that any changes to the obligations would come from the Borough Council, but in consultation with an agreement from KCC, because obviously, this agreement is very heavy on KCC obligations as well. Secondly, we sought to put in there that any new obligation ought to be by way of a bilateral agreement as opposed to a unilateral undertaking, and that again is so that all of the relevant parties are party to the agreement, so anyway, that's just a flag that we had looked to do that.
But I mean, if any changes were to be made, you're party to the agreement, aren't you? So I mean, how do you mean you want to be consulted about it?
Yes. So this is so this agreement applies obviously to this development. If a Section 73 application is made, and obviously that application goes to the borough, to the district council to determine, and in the clauses it said that if the borough council dictate that the changes are required, then a new obligation would be entered into. So we just wanted to make it clear that KCC were at the table in terms of determining whether the obligations ought to be changed or should in fact remain the same.
So how would that be affected in the wording then of the?
So it's.
Is it 11.1?
That's right.
Yeah.
So you've got, I think actually helpfully you've got some bold text in amongst the clause, and then you about halfway through you've got unless.
Yeah.
And then it says unless the borough council, in determining the Section 73 application, it goes on, requires consequential amendments to this deed. So insert there, unless the borough council, in consultation with an agreement of the county council, in relation to county matters.
Any comments on
We've
that?
seen a version of that wording, and we've agreed it. Yes, so we're comfortable with that.
Okay.
And then the second part of that, I think, is where it begins, in which case, again in bold.
Yeah.
And then it says a separate deed under Section 106 or Section 106A of the 1990 Act, as the case may be. And forgive me, I haven't got the drafting in front of me, but I believe it says.
I've got it.
Have you got it, Victoria? Thank you.
Which shall be entered into by all relevant parties in in brackets, which shall not be a unilateral undertaking. And then it goes on, will be provided to secure as is in the existing drafting.
Okay, and you've agreed, so that's good.
Yes, we've agreed both those changes.
Okay, thank you.
Yes, ma'am, that's to address that made a decision to stop at Section 73 coming in with a unilateral
Yes.
overriding everything, so.
Yeah. Actually, talking about the government's changes to things, I don't know if there's anything to be said about the changes being sought in relation to Hillside. Is that at all relevant?
Would you mind repeating that? I'm so sorry. I was in the middle of
Nodding
reading a
off.
transcript. Would you mind repeating what you just said?
I was just, yes, it's ever so warm in here. I can't quite
We
understand
thought we'd left those days behind in July.
I know, but it's very close, isn't it?
It's a real microclimate.
Yeah,
Yeah.
it's a micro. You mentioned Hillside, and then
Yeah,
everybody
no.
started looking at me, which was quite a terrifying.
Well, it's
moment.
just that you raised the last thing about possible
Yes.
government changes, and now there are the esteemed Lord Banner
Oh yes.
has
Oh, gosh.
is trying to get changes to the
Yes. Planning and infrastructure bill.
yeah, that's right.
Yeah.
The act in relation to the drop-in provisions.
That's true.
And I just wondered whether this would be, if this is relevant here. This is, of course, Hillside was a full application, wasn't it? Full permission. But I did read that there was, there may be some relevance to outlines on multi-phase development.
Yeah.
And I just wondered whether there was anything that needed to go in.
I think the answer to your question is no, because so is the law potentially in a state of flux thanks to the esteemed Lord Banner? Yes, not just thanks to him, but the Levelling Up Act introduces the possibility of amendments to Section 73 that I think we touched on earlier in the inquiry as well. So there's several ways in which the law that touches on Hillside and drop-ins may change. But it would be, unless the law actually changes, obviously, between now and you sending off your report, in which case obviously you could and would be open to ask the parties for their comments. Obviously I'm sure you might want to do that, or the Secretary of State might if the baton's been passed to the Secretary of State. Unless and until the law has actually changed, that none of us can or should make assumptions about how it's going to turn out, because these are not easy, to state the blindingly obvious, these are not easy provisions to work through, still deeply controversial, lots of parts of the planning and infrastructure bill, and who knows is the answer how it's going to pan out. So I think we all deal for now, and I'm sure we all will deal in closings, etc., with the law as it is. And if and when things do change, if that happens before you've reported, obviously you can ask us, and the Secretary of State no doubt will want to ask us, depending on the chronology, if things change before he reaches his final decision. But not yet is the answer.
Mr. Pereira, you haven't got anything to say about it? Right. Is anyone else?
Mum, yeah, sorry, it's not about law change, but if it's helpful to do it now, there's a discrete point on drop-ins that applies to KCC.
Okay.
And that's obviously in the developments delivering obviously a number of bits of county infrastructure, including the schools and the waste recycling centre. Now we'll come on to those provisions, but the agreement, certainly in the southern site, gives the option for delivery by the developer or by KCC. The approach taken by KCC is that where it is delivering infrastructure, and so in this case we've got an outline permission, and reserve matters obviously will be required for any school before it's built. The approach taken by KCC is that where it is delivering that development itself, it would have to make a Regulation 3 application, that is an application to itself to determine. And we interpret that as meaning that it can't actually submit a reserve matters application, and it would have to make a sort of separate full planning application for the school. In that context, that would, I suppose, technically be a drop-in application, but clearly it would be consistent with with the parameter plans, and we've looked to enshrine that in the agreement. And there are obviously controls within the agreement about the size of the school site, the location, etc. So we've looked to do what we can to ensure that would be possible. It would be a like-for-like sort of drop-in.
So as long as it's like for like, you think that could be accommodated?
Yeah, without sticking my neck out and interpreting Hillside, I believe it would be.
And obviously conform with all the conditions and parameters. And this would actually, I wonder if this would be apply to the NHS as well. It probably would, wouldn't it? If they're delivering.
If they put the planning application in for the design, they may.
We've still got Ms Thomas here, so would that be the case, Thomas, do you think?
Yes,
I think it's a slightly different point, because I think the NHS could make a reserve matters application, because they're not the deciding authority. The issue here is that Kent would be granting themselves permission. That doesn't apply to the NHS.
So Kent can't put a reserve matters in, whereas the NHS could.
Oh, I see.
So then it's not caught in the same way.
Ms Thomas?
Sorry. Yes, we're not caught by that Reg 3 provision. I suppose we would be open to make an outline or a full application if we were applying to build. I suppose there's nothing to stop us doing that as well.
Well, if you did that, then that would be a drop-in, wouldn't it? But you could apply for reserve matters, could you?
Yes.
Okay. Right.
Sorry, ma'am. Just I think the point that Mr. Stimpson's going to is that, so we have added in, Ken have added in drafting into the education schedules and the waste schedules that essentially deal with this point if they make a drop-in, particularly in the context of BNG. So at the moment, our application, we only have a voluntary BNG requirement, which is secured by condition. If Kent made a drop-in application for either the waste recycling centre or the schools, that is a new permission that would result in BNG requirements under the BNG regime. There was wording in the submission version of the agreement that you've seen that dealt with this. That wording has ever so slightly changed, although the principle is the same, but it essentially, and we've put it into the education schedule and the waste schedule to make it really clear where it refers to, but essentially requires Kent to provide BNG, their own BNG requirements, if they can, on the school site or the waste transfer site, whichever is relevant. And then if they can't provide their own BNG requirements on the site that we've transferred to them, then they will make an application to the master developer to agree a way forward for providing that required BNG on the remainder of the site. So that wording was in the submission version that you have seen, but it has evolved slightly with a bit more detail over the last week or two at Kent's request. And we've agreed to that wording, and Swale have agreed to that wording.
Is it just BNG then?
Just BNG, yeah.
And then that ties in with the conditions which have the target of 20% across the site, and obviously this would still be within the site, so it has aligned with the conditions. We discussed that with Swale and KCC.
Okay. Okay.
Yes. Ma'am, there's no objection to that.
Okay. KCC?
Yeah, well, yes, we're happy with the draft. Yes, unless you want me to talk more about it, we're certainly happy with the drafting on it. Yeah.
Okay. No, you've explained. Thank you very much.
Thank you.
Oh. Okay. Right, anything else? Because we've got to now go, haven't we, on to Schedule 14, which are the discount market sales, but I think we ought to have a break, shouldn't we, really? 'Cause, sorry, just realised what the time is. Can we just have a break just a comfort break for till 4:10, and by all means bring your cup of coffee or tea or whatever back with you. Okay, thanks. The inquiry's adjourned till then. Thank you. The inquiry to resume. In terms of what we're going to discuss next, I know we've got discount market sales dwellings just to go through, but Kent County Council have asked if we could do the highways and education tomorrow morning. So, sorry, I hope that doesn't mean you've wasted your time today. I know they have, yeah, but I'm sure they found it interesting.
Might be worth saying that having discussed this with Matthew Stimpson, who's not currently here, but I hopefully he can verify what I'm saying. We didn't feel that subsequent to the Highways Roundtable there was much change, and perhaps felt that could be dealt with relatively swiftly.
Hope so. Yes. I mean, I've picked up things that there's a few outstanding things, but hopefully it's not going to take too long, given that we've already done that in some detail, not that long ago actually. So can we turn to discount market sales? Well, actually, there's nothing I've got on there to raise. So is there anything anybody wants to put it to raise? Or
I think there's just one real point to raise. So the genesis for this schedule was that Swale felt that if discount market sale was to form part of the mix, they wanted a few more parameters around that included in the 106 agreement. So Swale's solicitor drafted up a separate schedule on that, which is what this is. And there is one point of disagreement, which is around the level of discount to market rent, which is appropriate. And our view, supported by Claire Dickinson, who's now left the meeting, is that 20% discount is appropriate, and that reflects the NPPF's glossary, which refers to those products being at a minimum discount of 20%, whereas Swale don't have a policy on this, but they have proposed a 30% discount. We don't feel that is justified by reference to the NPPF, which we feel is the most appropriate reference point in the absence of Swale having a policy. I'll of course let them explain why they think otherwise, but that otherwise we are agreed on this schedule, subject to that one point.
Mr. Thank you.
So obviously the NPPF talks about up to 20%. It is not based on any local evidence. We've got an HMA, which I understand that the developer has relied on.
Sorry, HMA?
The housing market assessment that the applicants have relied on. And in there is, although it's in relation to First Homes is being proposed. First Homes is a discount market.
Yeah, I know what they
sales, right? Yeah, sorry.
That's all right.
And that was assessed and by the consultants, and they believed that the council could sustain 30%. So whilst there isn't a specific policy on it, there is some form of evidence which is a little bit more than the up to 20% or in the NPPF that we're relying on.
The housing market, are you talking about SHMAR, or is this a different assessment?
No, it's the same one, ma'am, but because it was not a strategic housing market assessment, it was just a housing market assessment.
Right, okay.
So we just call it the HMA, but it's often been referred to as the SHMAR, and just for clarity, it's an HMA, not a strategic HMA.
Okay, right, thank you. So the assessment, it's not that recent, is it?
2020, so 5 years old.
Yeah, exactly. So 2020 it was done, and it assessed first the need for first homes, is that right?
And it just looked at what people can afford in the borough and what if you've got a discount market sale dwelling, what would be affordable to borough residents, and what they established that with something like a 30% discount, that would be clearly more affordable to borough residents.
Okay.
Could I just give you, it just was doing something completely different. I mean, it just sort of cut through it. The reference is to the document that's been talked about is 27.2.2. I'm not suggesting you actually turn it up now, but just for when you do. 27.2.2. And there's a couple of paragraphs on first homes on paginated page 56. And it is literally, I think, 2 paragraphs. It says that in the bit that's being relied on by the council, that this policy, which is to say the first homes policy, is still at consultation stage. It's premature to undertake detailed modelling of potential demand. Initial guidance suggests that 30% would be the minimum, and it's therefore helpful to understand all of that. And it's being looked at in the context of an then emerging policy about specifically about first homes, where 30% was the number that was being considered, and it, not only is it 5 years old, it was only provisionally expressing a view about something different to that which is what we're talking about at the moment. So it's not a goer in terms of founding an evidential or policy basis for something that departs from the framework position.
Yeah, I mean, if I recall, the government's first homes policy, because they did, I mean, that's been dropped now, I think. And that was 25%, wasn't it?
Starter homes were 20% discount, I think, and then first homes.
No, but 25. Oh right, yes, no, maybe it was.
The SHMA does cross-reference to what were starter homes as well. So there's so the HMA, as Mr. Duggan called it, there are a number of references throughout there to products being demanded for with a 20% discount.
Yeah, 30%. Was, I think, at least at one stage, the number for first homes. Just looking back over it, I think. Yeah. No, I know. I was asking you, trying to answer your question about first homes. I think it was 30%. The policy only crystallised in, I think it was 2021. So.
It didn't last for very long. Anyway.
No, it didn't. But the reason I mentioned that is because that's why the SHMA or the HMA was looking at then emerging draft government policy. So I don't criticise it for that, obviously. It's just it was doing what it was doing, but it was doing it briefly because it was only then an emerging draft policy.
The MPPF talks about a discount of at least 20%, and we have an evidence base in the form of the HMA which indicates that for borough residents a 30% discount would be something that they could afford, which is why we're suggesting the 30% discount.
I would just urge you then, if that's going to be the council's position, just go and have a look at it, madam, those 2 paragraphs, because it's pretty flimsy stuff in terms of trying to justify what Mr. Dygan's just said. It just doesn't say that. It does say that 30% would be what the council would seek to support for first homes, subject to detailed modelling that they never did because the policy was only in draft. But it's not the same thing.
Just to say as well, I know attention has been drawn to the first home section of the HMA, but there's a whole section before that about discount home ownership, referring to a 20% reduction. So that's been ignored by the council. There's a whole section from 3.31. They've gone straight to 3.37, ignoring the whole section about 20% discount.
And also the MPPF in the glossary below the discount market sales definition talks about other affordable routes to home ownership and cites 20% as a discount for other low-cost homes for sale as a benchmark threshold as well.
Okay. So is this going to be another schedule that's going to be a unilateral then?
No, from the council's perspective, it would be a blue pencil matter where the Secretary of State could adjudicate as to whether it's 20% or 30% as a discount.
I think there's a lot of evidence on why it should be 20%. I know, does this need to be a blue pencil matter? I suppose is the question, given the evidence.
Well, obviously the council. We obviously think so.
Yes.
That's what he's saying.
Yeah.
So you're going to agree to that then?
Yeah, I think we're in wider discussions over other matters, but I think I'll take that away and talk to Mr. Dygan and my team.
All right. Right, okay, thank you very much. Anything else on discount market sales? No? Right, okay, so should we, do you think we should just talk about this question then? Try and grapple with this question that I raised about key phases, sub-phases and so forth. Because really, we can't just ignore it, can we? You know, I mean, it does need to be consistent. You know, whether it's the conditions or the Section 106, and it needs to actually accord with the evidence, doesn't it?
Yes, ma'am. I think we have taken on board your comments, and I think your analysis was quite right, based on my understanding of the condition session. And as you say, there's the phasing plan, which is a plan for approval, and then condition A6 requires submission of a strategic phasing plan, which will identify key phases and development parcels. We moved the language in the 106 agreement to change that from phase to key phase, but I think you're right that key phase for the purposes of the 106 agreement isn't the same as key phase for the purposes of the conditions, which does lead to an element of confusion. The Section 106 agreement also refers to the concept of sub-phase.
It does.
Now, that was always intended to mean development parcel, and I think for clarity it would be helpful for us to refer to that as development parcel. As for the distinction between phases and and key phases, our view is that it would be clearest and logical for the key phase definition in the 106 agreement to map onto the key phase definition for the purposes of the conditions, and of course those will be outlined in the subsequent plan to follow, but has to be in accordance with the phasing plan. That has, in our view, limited practical implications for the Section 106 agreement. We've discussed this on a call with Swale and Kent County Council last Friday, and we've had subsequent correspondence.
Yeah.
As far as I'm aware, as at the current point in time, they were still just grappling with whether that worked from their perspective, and I would have to defer to them to comment. But for our purposes, we see the logic in establishing the key phases for the 106 in parallel to the key phases for the condition, and spatially that would be consistent.
Yeah, I mean, you basically have to, you know, because the the phasing plan just basically is an overall plan, isn't it? So it would have to be clear that the key phase doesn't really bear a relationship to the phasing plan as such, does it? Do you want to?
Well, just in terms of the condition, yeah. So the condition requires a sort of a site-wide strategic phasing plan,
yeah,
within which the key phases need to be identified, and then the parcels.
Indeed. Yes, but if key phase equals phase in the phasing plan, you wouldn't need a strategic phasing plan, would you?
No, I guess we're just not clear at this stage how many key phases there would be, and whether they would need to be a subset of the strategic phasing plan.
Well, the strategic phasing plan will identify key phases and development parcels. That's what it says in the condition.
Yes.
So you'll have to decide right at the outset. That's the way a condition works. It was all agreed.
Sorry, ma'am. Obviously, I haven't been involved with the conditions per se, but so you've got a phasing plan up top. That's conditioned.
Well, no. You've got the phasing plans, which are in the to be approved as part of the development. So
There's a phasing plan which is approved though as one of the drawings. So
yes.
And that's the strategic. That's a strategic phase.
Well,
phases.
It isn't
So it's just called the phase.
That's just called the phasing plan.
Okay, so the phasing plan, and then those like cyan colours and all that are then split up into key phases. And then phases within those are the development parcels.
Yeah, so it's
I think the point is that the key phases may not necessarily be the parcels. Yes.
Don't call them parcels. Please.
Not plots either.
I mean, in the northern site, I would say that it might very well be that the key phases and the phases on the phasing plan might be more or less the same, mightn't they? I mean, in the residential. So we've got, if we just look at the phasing plan, I mean, as far as I could see, hold on a minute. Sorry, I don't know where it is now. Could anyone? Oh, here we are. So we've got. I mean, we talked about four phases, didn't we? Which
is that CD 52.17?
Yes.
Just checking.
Yeah. Yes, it is. So phasing plan shows basically two phases, doesn't it? Residential phases, which I sort of rather took could be two key phases. Might not necessarily be, but they might be, mightn't they? And then you've got the open space, and then you've got obviously the road infrastructure, which in itself is a key phase. Is that right? That's what I understand anyway. So, but you know, they've got to put in as a condition A6, I think it is. A6, which, if I could find the conditions, I'd be able to tell you, basically requires, here we are, a strategic phasing plan. So it might be that the developer or the master developer, whatever we call it, decides that, for example, Tainham, you know, the pale blue might be, you know, perhaps there might be two key phases because it's quite big. I mean, it will be about, I don't know, 700 houses or something. That's quite big, isn't it? So it might be split up into two, maybe. You know, and then within that, then you've got the development parcels. And development parcels, as I understand it, are not plots.
No.
Parcels are groups.
Yeah. The development parcels are likely to look like the development structuring plan.
So I think I've got it clear in my head, I hope, anyway. But you have got to do all this up front, you know, and whereas the northern site, I would have thought, was easier. The southern site, of course, is a bit of another kettle.
And of course, the southern site then, and both sites are also linked by all the other triggers. So you've got certain triggers over land transfers to for the primary school, secondary school, and the NHS facilities. So obviously that will dictate which parcels can be in, which plots can be in those development parcels at the right time, and the phasing.
Yeah. I mean, if you turn to the development structuring plan, which isn't a plan to be approved, which is an illustrative plan, that actually shows, doesn't it, the these indicative parcels, which we looked at before in relation to the healthcare, didn't we? So that they would be in the sort of thing that I think is envisaged as a development parcel.
Yeah, that's right. The development structuring plan
itself contain a number of plots. So I don't think it's very difficult really, but you know, I think with the southern site, maybe getting your head around that is a bit.
Mum, is it helpful if our position on this at the moment is reserved. We believe that I'm sure we can find a way through it, but if it helped to just explain perhaps why we're being cautious on this point,
Right, go on then.
The first is, I think that we were proceeding on the basis, obviously, that the phasing plan had some sort of function.
It has.
Save that the phase is shown at potentially are meaningless, are they not?
Sorry?
Well, in the sense that the phase is shown on that phasing plan are potentially meaningless.
Well, no, they're not.
Well, how?
Well, I mean, the thing is that what you're interested in mostly is the strategic road, isn't it? I mean, that's that is a phase. You can be rest assured that's a key phase in both schemes.
Exactly, but no, we're also interested very much in the schools, yes. And that I think is where the important bit comes in. Now, as I say, we're talking about this, but the critical point, I think, from a school's perspective, but also other KCC infrastructure such as, footpaths and so forth. But those key phases then become quite important in terms of the size that they are and how much information they show. So, by way of example, if you're dealing with a school and you need a sort of strategy to come forward for the key phase in which the school is located, what you want to ensure is that the school and the infrastructures in place to connect to the school, that footpaths are in place and will be delivered, and that the housing is located, so that is not in isolation from the school, and that the order in which that phase comes forward doesn't leave the houses disconnected from the school, etc.
Yeah.
So just from a broad perspective, that's what we are very concerned to ensure, that when development comes forward on a phased basis, those phases, the detail that comes forward with those phases and the strategy for delivering those phases is done at the right level to ensure a well-planned development. So obviously with a fixed phasing plan, we had certainty at least as to what spatially what those phases were. If the key phases are to come forward and are left to be defined, so be it, but from KCC's perspective, we would want a seat at the table, at least in terms of approving or being consulted upon that key phase, that strategic phasing plan.
Well, the council can do that.
Yes, and we are, that's part of the discussions that are taking place at the moment as to how that's adequately secured.
Well, I don't think the phasing plan is meaningless, because it basically shows the sort of the highest level, if you like, of phasing, and as it's to be agreed, we're told that we're just looking at the northern site at the moment, that phase 1 is years 1 to 5, and phase 2 is 5 to 10. So, and the phase 1 includes the school, high level, but it might be that within that, and this has got to be submitted and approved, there might be, more than one key phase. As I understand it, or there might not. Maybe it won't be.
Or indeed that a key phase might straddle or an overlap and incorporate more than one phase.
Key phases might be developed concurrently, of course.
I'm sure it can be managed, but this is the reason why it's caused pause for thought. That's all.
Yeah.
And
it's got to be. It says A6 that the strategic phasing plan, which is the sort of overall phasing plan has got to be in accordance with this with the phase, this drawing.
Yes, but
Right.
again,
So that's where we starting point, and then the phases, key phases, and development parcels have to be approved by the council. That's how I understand it. I mean, it's not my plan. I'm just how I understand it from the evidence. That's all. If I'm wrong, then you better tell me.
That's correct interpretation, and we actually think that for education, there's a way of not necessarily needing to link into the key phases, because you can simply refer to the locations in which the schools are coming forward, and there's an overarching education strategy. Obviously, we're going to go on to discuss that later, but we think to address County Council's concerns around education, there is a way through which enables them to have sufficient certainty about the area to which the relevant scheme that they're seeking relates.
So, I mean, sorry, can you just explain it a little bit more then, just perhaps for... So, how you mean? You said there's a way through. So, what...
Sorry, one moment. For education, the triggers are to do with occupations across the site, numbers of dwellings, so the key phase distinction isn't relevant. There's currently a concept of an education phase strategy, which sits beneath an overarching education strategy, and it refers to this is on the southern one. Yes, there's the southern scheme. There's an overarching education strategy.
Which one is that?
On the southern scheme.
Oh, we're looking at the southern. Do we have a
Yes.
northern one as well?
I don't think we do for the northern, because there's only one school
Right.
one primary school coming forward on site. So I think we don't have the overarching strategy. We just have a single education strategy. And so for the north, it's quite straightforward, because there's one primary school. There's an education strategy submitted at the outset, which details the location of the primary school site, how that will come forward, linked to occupations. And so the key phase isn't really relevant. On the southern scheme, in the southern agreement, there's an overarching education strategy, which shows the location of each school, the order in which the primary schools will be delivered, how that delivery will link into occupations of dwellings across the development. Sitting beneath that is a phase education strategy, which sets out precise location boundaries of the school site within the education phase, details of access to that site, how that integrates with dwellings in that education phase. Now, education phase is currently linked to specific what had been termed key phases in the agreement, and I can understand that Kent County Council would want some certainty as to the area which is covered by that strategy, which sits beneath the overarching one, and therefore, for the purposes of the education schedule, it might be that the education phase could be described on a bespoke basis for this particular schedule, and could refer to the specific locations that are identified in the definition of education phase. There's no specific need for those to link to key phases. They can be set out on the plan as they currently are, but defined by reference to the 106 agreement specifically. There's no real need to tie them into the key phases. So I think for the purposes of education, there is a way of giving Kent County Council the certainty that they are seeking, because they, as they say, they don't know what a key phase might look like, and they want to have a degree of control.
So like the housing phases, in other words?
A bit like housing phases, yeah. So a bespoke approach for education. And then other than that, the relevance of key phase is largely for certain contributions, and I'm not sure that, I don't think that is a problem for Kent County Council, because for education contributions, they're all done on a, I think with the exception of one contribution, they're all for the delivery of specific schools, all those contributions are done by reference to numbers of occupations of dwellings across the entire site. So I've explained this to this approach to Kent County Council and Swale Borough Council. It's really for them to come back to us, but we've tried to find a solution at short, further to your correspondence.
Yep.
We're certainly trying to find a solution, and we're considering that. I mean, in terms of, at the moment, my reticence or reason for being cautious, and this comes in Schedule 3, which is the master developer obligations, and what we sought to do there.
Hang on, where are you, what are you looking?
Sorry, so it's in either agreement, but let's, if we use the south, and I'm now looking, Schedule 3 begins on page 37.
Hold on. Yep.
So, in a nutshell, this schedule's all to do with the master to developer taking sort of ownership of or responsibility for submitting the strategies and taking forward the scheme and ensuring it's done in a coordinated and consistent manner.
Yeah.
And one of the things acknowledged in this is that there are a number of what we call overarching strategies and then a number of phase strategies. And within that is a acknowledgement that they shouldn't be prepared in isolation from each other, but should be taken into account when those strategies are being prepared. So, as I say, so for example, I think if you look at page 38, actually, sorry, if you start on page 37 and you then got a list of the what are called here the key phase strategies.
Yeah.
And you've got there the list, the education strategies, the pedestrian and cycle route scheme, the highway works scheme, the public rights of way management scheme, and strategies required pursuant to any of the sort of key phase conditions. The idea is that you when you're preparing a strategy, your strategies for your key phases, if we call them the key phases, that you look at everything together, so that when you're designing your highways layout, when you're designing your footpaths, you have regard to where the school is, you have regard to where the houses are, and you plan it out all together so that nothing is sort of left as an afterthought. And as I say, we're considering the position, but that's one of the reasons why we're cautious, and that might well be a reason for moving, as you say, to actually adopting the key phase definition and making it consistent with the conditions. But if we were to do that, as I say, I think the what we would want is a little bit more control over the approval of the strategic phasing plan, so that we had some input and oversight over the size and layout of those key phases. So, as I say, there's a sort of sufficient size to provide that level of detail that those strategies require.
I thought that you were talking, weren't you, Keegan, about not having education as a key phase, but having its own phase.
It is, yeah. So it's certainly been presented to us as a proposal over the week, over the weekend. But that's what I'm saying. That's our reason for not jumping and agreeing that proposal, because it may well actually serve to work with the key phases, so that all of these strategies work together in relation to the same spatial area.
So what do you, I mean, you were at the condition session, weren't you? So in A6 is the approval of the strategic phasing plan.
Yes.
What are you suggesting?
Well, at the moment, as I say, this is being worked out, but we did have in the agreement already a provision for any changes to the phasing plan to be approved. But what we might be looking to do is build upon that clause. Again, it's in Schedule 3 to have an approval process for the or at least a consultation process for the draft strategic phasing plan before it's submitted under condition. But as I say, these are only discussions that have begun to take place today.
I see. Right. Well, as I say, a bit late in the day, really. But still.
Could Swale agree to something of that nature?
Sorry?
I'm just wondering if Swale could agree to something of that nature.
I mean, I'll so thank you. We probably can, and I'd just need time to make sure that my senior staff are in agreement. But I can't see a reason why not.
So that would actually, because it couldn't be in the condition, because your local authority has to approve conditions. Not, you can consult who you like, but it can't be that has to. Kent County Council has to have a hand in it, so it would have to be in a legal agreement.
That's understood, ma'am.
Yes, and we are looking at that. Obviously the concerns from the council's perspective is, one, can't fetter our discretion in making the decision. Two, any decision we make is in accordance with our constitutional arrangements, so we can't have an agreement outside of within the Section 106 without taking it, through the committee process, which might be required for that. So we've just got to look at that sort of thing. It's not to say we're not interested in. Of course, we want to work and make sure everything's working well and we're all coordinated on it. We just got to make sure that we're not undermining any pre-app process, any constitutional processes, or fettering our discretion. That's I think our principal concerns. But I can't see why we couldn't agree a process for agreeing the phasing.
Yes.
Okay, well, so that's a bit of work in hand then, is it, at the moment?
One would hope, ma'am, that with something like phasing, because it does overlap with, Kent County Council's interests, that we would be proactively consulting them even on a condition discharge application. Oh, sure. It's just, I can't guarantee that. Do you see what I mean? It may well not be a condition that's discharged for several years.
Yeah. Yeah.
I think you'd agree to the Kent County Council's wording on the Section 73 clause around them being consulted on county matters, and that's written into the agreement. So it seems like this is somewhat similar, because the key phases are clearly relevant to county matters, but given that they govern the approval of schemes that are submitted to the county. So it's
we're certainly not wanting to skimp on the consultation. It's just whether, when the application comes in, the person at the time, and it might be somebody very different, will they recall the conversation that we've had today? So trying to build in some mechanism to remind them that they actually need to consult with Kent on this.
I think that's the purpose of the combined panel that's drafted for. That's what Kent County Council specifically asked for, was a seat at the table, and the combined panel in Schedule 3 is their mechanism for achieving that. And of course, you've been discussing that together, so and we're funding it.
Well, those are the discussions which we are having. And that's what I think Matt is actually referring to.
Understood. Thank you.
Where's the combined panel? Where does
It's
that?
the very final schedule of the entire agreement.
Oh, I see.
Schedule 3 of the southern scheme, and I think the same on the northern. Bear with me one sec. Yeah,
well,
they call it development coordination and monitoring.
But the combined panel doesn't say anything about the county council, does it? Oh, yes, it does.
Yes, it does, yeah.
Well, of course, you know, it might very well be that the county council and the borough council are one
Quite.
body, mightn't it?
Yes, well,
Quite
yeah,
likely.
but we're also bearing that in mind.
In which case, presumably, the problem would go away, would it?
You'd hope so.
Unfortunately, we don't have a crystal ball.
Well, no, but it looks, yeah. Well.
Yeah, you would hope, ma'am, but even within one organisation, sometimes people don't get consulted or don't talk to one another.
Well, no. I think that happens in lots of walks of life, doesn't it? Okay. So you're still talking about that anyway.
There's certainly no resistance. We're looking to find a way to both make sure that we're not compromising the scheme of delegation or the council's constitution, but we do completely get what Kent are talking about. We just need to figure out how we can make it work.
Okay then, jolly good. Thank you very much. Just looking at the other things. Oh dear, if I can find the note. Here we are. So this issue about key phases, sub-phases and so forth, we've talked about that, haven't we? And I think we're sort of at one on that, aren't we? It's going to be one with the conditions is what I mean, really. The legal agreements will concur with the conditions in terms of key phases and development parcels.
That's certainly the position we hope to get to, yes.
Right, okay. Now, in terms of enabling works, we spent a bit of time, didn't we, at the conditions session talking about what was enabling works were, and I'm presuming they mean the same thing as a preparatory operation in the section 106, do they?
The section 106 is narrower. So
Is
obviously, yeah, because obviously what triggers a implementation of the planning permission for the purposes of the planning permission itself is different from commencement of development for the purposes of section 106, which...
Could you explain that?
Yes, that's... So... Sometimes, well, there will be operations which you can undertake, for example, drainage works, which would trigger the implementation of the planning permission, but won't trigger the Section 106 agreement. So commencement of development for the purposes of Section 106 would exclude, for example, putting in your drainage. That does so it's just stopping the Section 106 from starting off. I don't think there's any massive relationship between the two. I think they usually can stand separately. I'm kind of looking across at Victoria here as well. I don't think there's an awful lot that needs to be read into enabling works for the purpose of the condition. And
so if you put some services in, then that wouldn't be counted as commencement of development
for the purposes of Section 106. Because some of the triggers are triggered on commencement. Kind of, in a way, it delays certain triggers within the Section 106 itself.
Well, so the definition in the Act, then...
Yes.
I mean, it's basically when a planning permission is implemented. So you're saying that the planning permission would be implemented when services were put in, but that wouldn't count as a commencement of development.
For the purposes of Section 106, yes.
I see. Okay.
So what we'd want to know is we'd want notification of implementation of the planning permission, so that we know that the clock has started to tick, right? And then we would want to get notification as to the commencement of development for the purposes of Section 106. It's standard in our, it's certainly in our drafts.
Yeah, okay, that's fair enough. But what about enabling works then in the conditions? I mean, because there is a crossover, isn't there?
I think we haven't necessarily considered the definition of enabling works via the 106 agreement, and that the definitions appear to be slightly different.
Appears to be wider and would include preparatory work.
Okay, well, in terms of enabling works, in my note that I sent round, I think I put in there somewhere. I can't find it now, but anyway, I'm sure you've all had it. I put the conditions which I think should include and not include enabling works. I haven't had any response to that, so I'm assuming that everyone agrees. Apart from C5, I think Mr. Digan, somebody came back on that one. I think it was Mr. Gambrell actually. But I'm assuming that everyone's happy with the enabling works that I've put down there. So that would be in the definition then in the draft conditions, and the actual conditions that applies to. Okay, no response. So I'm going to take it as agreed then.
I'm trying to work out what the impact of that is for the purposes of the Section 106. I'm not sure there is. No, okay.
It's basically that the reason I brought it up was, well, for starters, I haven't had an answer, but also because I thought maybe preparatory works was the same as enabling works, and now you've told me it's not. So now I understand that the two are different, so we don't have to have them, the conditions and the Section 106 at one on that particular matter. Okay.
I will need to speak to my group on that particular one, because I think we might have some concerns.
Okay. Well, if anybody has any dispute, you have to tell me fairly promptly.
We're just looking at it.
Sorry?
We're just looking at it now. We'll come back to you.
Right. I did send it some time ago, so. Are we moving on? So we've got on the southern Section 106, then we've got a definition of the SSRR, haven't we? On the northern one, I don't think we have we? I just wondered whether there's any reason for that or not.
Generally speaking, I think where we've got a definition like that in the front end, it's because it appears in multiple schedules, and generally where a definition only appears in one schedule, we only have it defined at the table at the start of that schedule.
I don't know if we've got it anywhere, have we? Maybe we have got it in transport, have we?
So it's possibly because whilst the Southern Agreement needs to refer to both the SSR and the SNRR,
Yes.
The northern one, I think, only has to refer to the northern relief road because there's no crossover between the two agreements.
Right.
Does use slightly, so the Sittingbourne Northern Relief Road Extension, so the acronym's SNRRE, and if you do a search for that on the Northern Scheme, you'll references to it.
Okay. Right. Okay, thank you very much. And yeah, sorry, just one thing on Schedule 3 that I think we were just looking at that on Schedule 3. Is it true, is it the case that overarching strategies in Schedule 3 are the same as site-wide strategies in the planning conditions?
No. The overarching strategies defined in the 106 agreement are specifically both overarching strategies secured pursuant to the 106 agreement and also any strategy submitted pursuant to the overarching conditions. So it would capture both, whereas the conditions the overarching strategies for the purposes of conditions are therefore a subset of the overarching strategies as defined in the 106 agreement.
We don't have overarching conditions, we have site-wide.
Site-wide, but the definition of overarching condition is meant to be is meant to correlate with that.
Yeah, I think
it's
kind of like got a bullet point there to say, so overarching conditions means the following conditions. But because those conditions hadn't been resolved at the time, I think the numbers that are going to be going in there.
And they would be, logically, the site-wide conditions, yes.
Yeah. So overarching conditions are site-wide conditions. Is that right?
Yeah, just a thought on that. Actually, we were going to have a list. Sorry, guys. We were going to have a list of conditions, of course. But I suppose currently. Well, your discretion as to how they're numbered and what ones they're included, and also ultimately the Secretary of State. So whether we can actually have a list of conditions and have to have a more general definition. Sorry, everyone. That's only just occurred to me.
Yeah, no, it's a good point, actually. I mean, I prefer not to be... And also, it might, Secretary of State might not think that some of them are necessary, it's...
I think the idea behind some of the drafting, ma'am, is to make sure that we don't try and cross-reference or try and go outside the document. And if there is anything that we want dealt with in the document, that it's attached, including any plans, which might not necessarily be condition plans, but they're important plans for the purposes of the Section 106 and delivering any strategies under that.
And ma'am, as you know, if there were to be NMAs and Section 73s and so forth, condition numbering might change, and then the Section 106 is referring to something with it.
So is there a general consensus that those should be taken out then? Over actual setting out the conditions in the Section 106? Is that what you're saying?
I think there's a general consensus that there needs to be somehow we need to capture the site-wide conditions without referencing the condition numbers, which I think was the original intent. Yes, I
How are you going to do that?
Some general wizardry, ma'am.
Well, I mean, I can't promise that, that the headings, I mean, you're calling them something, but Secretary of State might not want to use that terminology. I prefer the conditions aren't put in here, really, but I mean...
Could we come up with a suitably worded way of describing site-wide conditions that we can put in here? Perhaps with, there could be some requirement to submit something post-grant of permission which identifies in detail what they are, following...
What, you mean another condition we need? Oh, please.
Something in the 106
Well, maybe
agreement.
once we know what the Secretary of State may or may not agree, there could be a discussion about, or I'm going to say an agreement to identify what those are that are conditioned. But there are some specific ones which are referred to in the Section 106, which are specifically identified. I think the last bit, any strategy required to be submitted pursuant to any overarching conditions, it's a sweep up, trying to keep some flexibility within the agreement to capture things which we might not have captured, as opposed to having a closed list.
Well, why do you have to put a list? You could just, any strategy required to be submitted pursuant to any key phase conditions, and you go to conditions and, you know, why do you have to list them?
I think that sounds a good solution.
Sorry?
I think your solution is a good one.
Would you like to repeat that so you can put in there?
Well, I just think that, you know, this is a legal document which is separate from the conditions, so I just don't really see why we have to list all the conditions out, really. Or any conditions.
No, I think we agree. We didn't draft it, and I think we hadn't quite, that had been square bracketed to work out how to deal with that. And I think
ordinarily, we would do it for certainty. Of course, as lawyers, we like absolute certainty of things, so that when we're talking about something,
is there in this
no, but we can certainly work with a broad definition. Yeah.
I think you'd often have a situation where you've got a 106 with a draft decision notice appended, and you're pretty certain at that point what the numbering will be. But clearly, that's not the case here. So perhaps it certainly merits a different approach, I think.
Right. Let's see if we can just knock something else off, shall we, off the list? So is there anything else about the notices and the Schedule 2 and 3 that anybody wants to raise, or are we happy that we've covered things for that?
The notices, ma'am, they're incomplete until the agreement's actually been finalised in a final form, and then a read-through will pick those up.
I appreciate that, yeah. But, I mean, there's nothing that's likely to change in any material way in 2 and 3.
I wouldn't say material, because all
it is
identifying notices. You will provide a notice because it's required by Schedule 15 or whatever.
But, I mean, I was told that there have been changes since
yes.
I've got this document. What I'm asking is are there any material changes to Schedules 2 or 3 that I need to worry about?
To Schedule 3?
Well, either of them.
Yeah, sorry, Schedule. This is on the development coordination.
Yeah, Schedule 2.
Oh, sorry, I thought you were talking about the notices. Sorry, my apologies.
No. The two schedules that we've got here. Schedule 2 notices and Schedule 3 development coordination and monitoring.
Yes, Schedule 3 will have amends to it. We've just discussed that.
Well, we've just discussed the conditions, haven't we? And but there might be amendments as a result of our discussion just now, but I'm talking about any amendments that were in the discussions prior to this session, because you told me that there was an amended document floating around which none of us have seen. That's all I'm asking. In other words, don't want to get the final document and then find there's something in it that I haven't asked a question on.
No, ma'am.
Yes.
On the Schedule 3 coordination, that's the matter which we've just been talking about with regards to with KCC about what has to be delivered and coordination. The way it's currently drafted doesn't work because it does fetter discretions, we believe. So there will be amends to that, but not to change what we're trying to achieve.
Okay, fine. Thank you. What can we do that's just going to take us a little time, I wonder? So education and...
Sorry, Mum.
Yeah.
On the progress monitoring on page 39, this is a 6th monthly report.
Progress monitoring, yep.
Southern, section 106.
Mm-hmm.
Page 39.
Oh, hang on. On the southern one.
Yeah. Just...
Yes.
Can we have... I think it would be useful to have... It says there, in the definitions of progress report, it sets out a description of it. That's really quite brief. Would be a model one or an example one, so that we know what we're getting, so there's sufficient detail, because this is the important part. Well, it's every 6 months.
No. When would you like the model?
Well, it needs to be appended to this document so that they follow the form of it.
What sort of template, you mean?
Yeah, in effect, so we all know what we're getting and what's to be adhered to. Because I've seen monitoring reports which are 2 lines in a section, and I've seen monitoring reports that are, you know, masses of pages of detail. It's very difficult to say that it's not been provided in sufficient detail if you don't set out the amount of detail you require at the initial stage.
It
What do you think?
looks to me that the progress report is kind of like more like an Excel spreadsheet type document, saying these are the number of houses we've built to date, how many... I think there's an overlap there with, I suppose, with like the housing delivery strategy and...
Yeah, so our view is that the housing schedule actually will provide all of that information. That is really the vehicle for managing progress on delivery of dwellings and affordable dwellings through those 2 tiers of submission that we described earlier, the housing phase delivery statement, and then sitting beneath that, the housing delivery scheme for each residential reserve matters area. Kent County Council drafted this schedule. They're not party to the housing schedule, so they felt that they wanted something to cover delivery of dwellings, and the reason that they wanted that in this schedule was because it feeds into the education provisions and the way in which education calculations may need to be recalculated if the dwelling mix alters. So it's actually geared towards them being able to monitor the education provisions, and really they hadn't seen the housing schedule and engaged with that, which deals with that in a very sort of detailed and granular way. So actually it's really the housing schedule that's doing that job, and this is a sort of top-up which is really designed for KCC's purposes to try and monitor this from an education perspective. It might sit better in the education schedule, but
why can't they just look at the housing monitoring?
it's specifically designed to deal with this point about, it's a bit difficult to discuss in isolation because it feeds into the education schedules, which we're not discussing right now, but that because Kent County Council aren't party to the housing schedule and they're not receiving the housing phase delivery statements, they separately want to know what's happening in terms of housing, because it will affect whether or not their contributions need to be recalculated. So I would say that the housing schedule is the primary means of monitoring delivery of housing and mix and dwellings and affordable dwellings, etc. This looks, I can see why it does look like more of an overarching progress report, but it actually wasn't designed to do that job.
Well, why can't it go into the education section then? Education schedule, if that's what it's intended to do.
I think, just, yeah. Okay.
Sorry, I haven't put my mic on. How many reports are we having here on different things? I mean, we want one set, presumably overall, from a management perspective, so that you get an overarching view for all parties. I'm sure that's a benefit to the owners as well as to the master planner, the master developer, as well as the authorities involved, is if you've got a housing bit and a bit here and a bit there, it should all be reported at the same time.
I would see this as sort of duplication, this one, and I would rely upon the housing schedule to be the one that secures the details in a very granular way of the housing development. I'd be happy for it to move to education, to the education schedule, but
we have no objection to it moving to the education schedule.
Yeah, there is just one issue, is that obviously the housing delivery statement is only for the southern scheme, not for the so that report is actually for the southern scheme, because the idea is to across the whole scheme, because it's a massive scheme compared to the northern one. So the northern one doesn't have that. So it might be, that report might be, I'm going to say, a junior or a younger brother version of it.
So there's no provision. There must be provision. So
with regards to the actual delivery of the phasing, yes, in the northern one, that is. But with regards to the southern one, there's actually a delivery statement which tells us about the number of units that have already been delivered and how many they're expecting to deliver and in what phases.
Yeah, so for the northern scheme, you just have that one tier. You've got the housing delivery scheme, residential reserve matters area, but that would, as Mr. Fitzpatrick says, provide a detailed.
Sorry, where on the northern one? Which clause are you looking at?
It's page 93, and it's the definition of housing delivery scheme, residential reserve matters area, and that will inform the council as to what is coming forward.
But you're saying the county council wouldn't get this?
We don't at the moment receive it, but I think just looking at it, it probably would give us too much information almost. It's quite detailed. I think you just want a summary of the housing numbers really, and.
Well, what's wrong with putting it in your educational schedule?
The thinking there was just that Schedule 3 just provides almost like a summary schedule of how the scheme would be coordinated and managed from a master developer perspective. That was just the thinking, so that there you have in one section those obligations of the master developer to coordinate the development, and that monitoring of progress and housing numbers was seen as part of that.
Well, this progress monitoring, I'm not quite sure that everybody's at one with what its purpose is here. Because Miss Bonnie's talking about a sort of general progress statement every 6 months. I think that's not what's intended, is it?
That's not what was intended. That wasn't why it was drafted. It was, as I say, drafted by Kent County Council to pick up this point about education. So there's not a...
If it's only relating to education, why on earth can't it go in the education section then?
I suppose as it stands, is it not useful just to have it as it is? It's quite useful that we report to the County Council and the Borough Council every 6 months on progress, and that could be way earlier. That could be
general progress on everything.
Yeah.
Well, okay, well, that's fine.
But that's in there as it is. I don't think it needs a template. I think
that's not the intention.
No, I think that what it was asked for in the first place related to the education.
Right.
But as it's drafted and as it stands, I don't think it does any harm, and I think it hits the requirements of what.
It's not just education. Obviously, you've got triggers throughout. Yes, you've got the notices, but you've obviously got financial contribution triggers, which are linked to occupations within. Various phases, etc. It is very useful information to have, and I say that from carrying out due diligence exercises on developments and how they're progressing. And for a lawyer doing that exercise, it is invaluable information to be able to say whether or not obligations have been complied with when they're supposed to be complied with.
Thank you. So basically coming back to Miss Bonnie's point then, which is about 10 minutes ago, she was asking for some sort of a template as to what should be provided in this, which is a reasonable question. So what's the answer to that?
I think we felt that the sublims of progress report detailed what that has to contain in quite a specific manner.
Oh, sorry, when it says a condition, what does that, what condition? We haven't got planning.
The definition, sorry, I think I may have said.
So where's the definition?
The definition of progress report has a number of limbs to it, which says what it needs to contain.
So it's not a condition. It's not.
No, and it is just to be clear to Ms. Bonnie. It's the total number of dwellings for which RMAs have been granted, broken down by dwelling type, size, and tenure, and by each key phase. The total number of dwellings built and occupied or ready for occupation, broken down by dwelling type, size, and tenure, and by each key phase, and details of the approval of any revised housing mix. So, I'm not sure if there's anything that Ms. Bonnie feels is missing from that specifically, but it does say what it is, not just a general progress report. It does say what it has to contain.
I think the point is that it's consistency in what that report looks like. So, a report written by A this month, in 6 months' time will be written by B, which will look different, I presume, is the point which has been made. So, in other words, a template.
I think we're comfortable with the definitions there. I don't think we need to append a template to the section 106 to show how the progress report, which is defined, is going to look. I just don't think we need to do that.
It does seem to be fairly specific, doesn't it? Don't you think, Miss Bonnie?
Oh, well, I explained. I've seen a few different types, and
but they might not have been defined like this, might they? To be fair,
I've seen quite a few of these as well. So,
okay, well.
But I think in there, if it's supposed to be reporting, it's what's been delivered. Is probably also looking at what's on the horizon and what the big risk factors for that delivery is for them, so that those partners that are going to be delivering or expecting delivery of things know that. So, if you can't get, major infrastructure in, that might affect the phasing of something coming up that's expected to be.
Mm-hmm.
But again, you can write 2 lines or you can have 20 pages. And as you say, it's consistency, being able to assess from period to period the same report.
Anybody want to say anything about that?
I mean, if it would help from our perspective, all as Mr. Fitzpatrick mentioned earlier, all I would envisage is a simple spreadsheet with figures on. I mean, obviously clearly set out so that you can identify this information, but a spreadsheet that is then, updated on a 6-monthly basis with the figures. I don't think it needs a whole load of text alongside it. It literally is numbers of units.
I see. Okay. Right. Okay. Well, if we can get any further with that. Okay. What time is it? So let's just have a look and see what we've got left to do then. So as you say, we hold on a minute. We've done quite. So, I mean, highways, as you say, we have had a recent, very detailed discussion, so there shouldn't be too much to do with that, I hope. Education, I haven't really got anything much, so, to be honest. So, I don't see that's hopefully going to take too long. Sports facilities, a few bits and pieces, I suppose, for that. And then they're just the mortgagee protection. That seems to be a new thing we haven't discussed.
We could happily briefly cover that now. That's quite
Yeah,
straightforward,
all right.
as well as perhaps environmental.
Okay. Mortgagee protection, that's 10. Is that 10 on both of them, or oh no, 13 and 15.
Yeah, I think it might be opposite for Ms Fitzpatrick, perhaps just to talk through that, given its
Hold on,
Swales
just get
template.
it first. 15. Let's just see. I'll just get it first, and then.
Oh.
Anybody got a page?
It's 108 on the north, real page.
Thank you. 108 on the north, did you say?
Yes, that's correct.
Do you know what? I think that I don't know why they're set out in different ways, these two, but in my opinion, the one for the north is so much easier to understand.
That is the town legal template, and unfortunately the southern one was taken out of our template and put into an alternative form.
Go back to your template.
If we go back to March with our template in the 106.
Mr. Stimpson, would you like to explain?
You've opened a real can of worms there.
Is that KCC causing confusion?
There's a joke about how many lawyers somewhere.
Well, yeah, okay, well.
There's an awful lot of them in this room.
Well, exactly. Anyway, I shall leave it up to you, obviously. Right. Oh, hang on. Don't think I have got it. Yeah, mortgagee protection. So does somebody want to just explain these then? Did you want to?
Yeah, sure.
Yeah.
Ma'am, very, very simply, it is if the RP goes down the drain, what happens to the affordable housing?
Right.
So it's basically the mortgagee, or the mortgage with the mortgagor, or the chargee. Let's call it that. Let's stick with easy terms. If the chargee steps in exercise of its charge over the property, it takes it free of the affordable housing provisions, so that they can get full market value. Because the way they used to be drafted is because of the affordable housing restrictions attached to the charge, RPs could only borrow so much money. So they requested these mortgage protection provisions go in so that they could borrow at full market value, so long as the chargee was able to step in and reclaim its full value. That's effectively what it's about. And the drafting which has been adopted here is from the GLA and has been accepted by RPs, certainly across Tunbridge Wells, Maidstone and Swale. The only additional element to that is in relation to the discount market sales, because that's a new product for us.
I see.
And that's basically it's in a nutshell, ma'am.
Thank you, very clear. Anybody got any comments on that? Okay, thank you. And which was the other one you thought we would do?
Environmental.
Oh yeah, that was just so that's schedule 16 on both of them, I think. Anybody give me a page number? Sorry?
It's 138 in the north.
Oh yes.
And 131. Oh, sorry, 134 in the south. No, 131. Sorry.
131. Yeah. Okay. My only question relates to the air quality damage cost. I know we had the round table, didn't we? So do we have? We discussed that, I think, didn't we? And presumably, was this the same sums as were included in that discussion? I would ask.
So, ma'am, the calculations, the way that it's undertaken is kind of set out by DEFRA, and there are changes that get made to the emissions factors by DEFRA, and they reflect the fact that air quality in some areas is improving. Mm-hmm. And so from time to time, DEFRA update the information relating to emissions, and as that's been updated, the calculation has been rerun. So the figures, and I can't remember exactly when we had the session, but I'm pretty sure the figures have changed since then, reflecting the change in the way that DEFRA require it to be calculated.
When were they updated? DEFRA update?
I'd have to get back to you on that, ma'am.
Okay. And so these figures in here reflect the most up-to-date?
Yes, that's correct.
Very different, aren't they?
They are. They've come down.
All right.
But it, you know, from the council's perspective, the calculation needs to be undertaken in accordance with DEFRA's requirements, and so we've done. Yeah, they've changed the factors, and so the amount has changed.
Anybody got any comments? Yep. Okay.
Do you want to reserve? Could I just mention one brief point on the environmental schedules, which is just that there was an omission in the northern version, which we picked up on post-submission, which was that the air quality working group, which is secured in the southern schedule, was missed in the northern one. So we have since translated identical provisions into the northern 106 agreement, so that working group is established in respect of both developments on an equal basis.
Okay, thank you. So in terms of these two schedules, they are, apart from those changes, there's been no material change.
That's correct.
May, I would say
Yes.
I'd just like to check with our air quality with Nigel tonight, and may I return to you tomorrow morning if there's anything major, but I don't think there is.
Okay.
May I?
Okay, thank you very much. Right, okay, good. So, and then we've got the stewardship arrangements to talk about, and the Kent Downs National Landscape, which we talked quite a lot about. Should we just quickly look at that?
Ma'am, if I can suggest, I think the open space and the stewardship are closely aligned. So I think probably those be dealt with together.
What, the National Landscape?
The National Landscape is separate.
Just with the National Landscape Unit are going to come along tomorrow. They looked at the agenda and saw that it was the final item, so they thought it would be tomorrow.
We'd not discussed it now then, had we? Right, okay. But I mean, I think we've made pretty good progress. We've done that,
We're just mindful of National Highways being here, wondered whether maybe we could touch on.
We were asked to do that tomorrow.
Yeah. Oh, okay.
Yeah. So, yeah, education, sports, highways, national landscape and stewardship. Do you think we'll get through all that tomorrow? Yep.
Yes. So I know Katie Miller from the National Landscape Unit is coming along, but unless there are, it could be that unless there are questions, that there's not a lot for her to say, and she understands that.
Okay, no, that's fine, thank you. Right, okay, well, shall we call a halt then? Is everybody happy to do that? If you're sure that we're going to finish tomorrow, because that's obviously what we've got to do, if you're happy with that. All right, so thank you very much. We will adjourn till 9.
Sorry, can I just confirm that we have no comments on your email about the enabling works condition? Apologies, we missed an email from Mr. Bashforth confirming that.
Thank you very much. Okay, that's fine. Please make sure. Have you got our schedule? Is there? We need you to put your details on that before you go, please. And we'll adjourn till 9:30 tomorrow. Thank you very much.